Good afternoon. Welcome to the Appellate Division First Department. We have some 7 hours of argument time that have been requested this afternoon. So I ask that you listen to the calendar call and ask only for the time that you absolutely need. We have your briefs, we have the record, we're fully familiar with the facts of your case. So please, as I call the calendar, ask only for the time that you need. Thank you. Okay, People versus Matthew Hall. Five and 2 and 4, thank you. Duke or Duque versus 50 Clinton property. 4 and 2 and 2, thank you. Alvarez versus Brashida.
Appellant, 5 and 1, Your Honor.
5, 1, 3 and 3, thank you. Thank you. H. Trinity versus Smith Anderson. Five, 2, 4 and 4. People versus Carl Smalls. 5, 2 and 5, thank you. Little Cherry versus Cherry Street. I'll give 5 and 2, 4 and 4. 5, 2, 4 and 4. 5 Star Electric versus MTA. I beg your pardon? 5, 2 and 5, thank you. Mercedes versus 680. It doesn't appear that there's a respondent here. Do you want to still argue? Okay, I'll give you 3 minutes, as no one is here on the other side. People versus Ronaldo Morales. 4, 1 and 3. NYCTL 1998-2 against Bethelite Community. I'll give 4, 1 and 4. Thank you. Mortgage Stanley versus Ciccarelli. Is there a respondent here? Respondent? Okay, your respondent is not here. I'll give you 3 minutes. Georgia Malone versus E&M Associates. I can't do half minutes. I'll give you 1. Or do you want 2? Okay, I'm going to give 6 and 1, 2 and 6 and 1. Did I get everybody? I think so. Okay, People versus Ernest Bristell. Okay, 6, 2, and 6. Thank you. Chris Grant versus Brohawk Films. I'm sorry, Brohawk Films versus Digital 7. Do you see a respondent? Is there a respondent on the other side? Okay. Okay, do you want to argue? I'll give you 3 minutes. Everybody's afraid not to. Okay, I understand. Farage versus Tower Insurance. 5 and 2 and 5. 865 First versus SNY Division of Housing. I'm sorry, I didn't hear. 6 and 3, did you say? I will give you, I'm sorry, 6, 2, 3, 4 and 4. 300 Wadsworth versus New York City Division of Housing is submitted. For Wadsworth versus New York State Division of Housing. Is the respondent here? Okay, tell me the time you request. Okay, I get to make the final decision, 5, 2, and 5. Lakia versus, I beg your pardon? You can hand that to the court officer when you come up for argument, okay? At argument, thank you. Lakia versus Volchanuk, that case has been adjourned. First case for argument, People versus Matthew Hall. You may begin.
Good afternoon, Your Honors. On behalf of Matthew Hall, Alexander Valdez with the Office of the Appellate Defender, may it please the Court. After the prosecution indisputably wasted all but 7 days of their statutory allotted speedy trial time, they engaged in blatant gamesmanship behavior that made a mockery of the law and undermined Matthew Hall's rights. I'd like to start first by discussing the forfeiture issue. I do recognize the Court's recent decisions on the issue. However, those holdings incorrectly applied Galindo and didn't address the clear contradiction between its rulings and still standing precedent in People v. Sullivan.
So let me ask you before we get to that, there's a waiver in this case.
Yes, Your Honor.
So wouldn't the speedy trial claims be waived?
No, Your Honor. The waiver was invalid because the Court failed to acknowledge that Mr. Hall was waiving the most important dispositive issue in his case, statutory speedy trial. And while that's not necessary in every single case with a speedy trial claim, following Thomas and the model colloquy from jurists and practitioners, the best practice to ensure that somebody like Mr. Hall—
Well, there doesn't have to be any litany. I mean, we know that. And the judge did go through the sections and then gave some examples. And there was a written waiver here that the defendant indicated that he went over and reviewed.
Yes, Your Honor, but even with that holistic review, the Court did not take account that the very day that Mr. Hall took his plea, he swore that he would never waive those rights. And yet the very same day, just hours later, he took a plea that did waive those rights. It would have been very easy for the Court to simply ask him, are you sure that you're waiving your statutory speedy trial claim? And that's a type of inquiry that, while there is no particular litany, Thomas recommends and the model colloquy recommends must happen. Now, Your Honor, turning back to the forfeiture issue, which I understand is pressing for the Court, I recognize the recent decisions, but Galindo does not control here, Your Honor, and the decisions do not account for People v. Sullivan, which is still standing law and directly applicable in this case. So in Sullivan, this Court applied an amendment, just like the one here, retroactively, because it was one that amended appellate procedure. The cases are identical on nearly every level, Your Honor. In Sullivan, back then, New Yorkers were not able to raise suppression claims after they pled guilty. The legislature changed that. This court applied that change retroactively to cases that had pending appeal, or that were pending on appeal, at the time that the law took effect. This is identical, Your Honor. 3030 used to expire with a guilty plea. The legislature clearly changed that. And yet the court declined to apply it retroactively, just like it did in Sullivan, even though this is an amendment governing appellate procedure.
So you've already said that you're aware of Galindo, and you're obviously aware of our own case here, where we've already said no to this, which is People versus Almond.
Yes, Your Honor, in Merchant and Santana, the court recently ruled, but very briefly, that Galindo is the reason why this statute does not apply retroactively. But that's not the case, Your Honor. Unlike the statute in Galindo, and unlike nearly every single other statute in the 2020 reform, this amendment addresses appellate procedure. And the Court of Appeals, this court, New York statutory law, all dictate that those types of amendments must apply retroactively. And that's particularly important in cases like this, Your Honor, where the prosecution blatantly violated Mr. Hall's rights. The consolidation motion that they filed was an act of gamesmanship that cannot be excused under CPL 3034A. They filed this motion after not stating ready for 2 years, after the court had told them that they had wasted 176 days of undisputed time, which respondent concedes. Rather than state ready for trial at the first court date after that decision, they filed this motion in court, on the record, despite telling the court twice over the preceding 2 years that Mr. Hall had 2 indictments, that the cases were unrelated and they had no plans to consolidate. It was untimely. It was 2 years past the 45 statutory deadline, and the court denied it as such. But what's more, Your Honor, the trial court explicitly said that this was unacceptable last-minute statutory change. But they erred by declining to exclude that time, or by declining to charge them, and does not follow, Your Honor, with this court's precedent in recent cases. For example, in Richardson, Your Honor, the only reason why the court did not exclude a motion that was meritless was because the prosecution had a good faith basis to believe at the time of filing that it had merit. That's not true here. Your Honor, in making 3030 survive guilty pleas, the legislature signaled that it is such an important right that people need to be able to defend it, even after guilty pleas. Your Honor, I ask that you dismiss the indictment and reverse. Thank you.
Thank you.
May it please the court, Andrew Seawald for the People. Good afternoon, Your Honors.
Good afternoon.
The court's recent decisions, as was just mentioned during my adversary's argument of Scott Merchant and also the Santana case.
Should we reach this case, given what counsel says about the last-minute strategy that the court seemed to indicate took place with regard to the speedy trial issue? The fact that the defense here was obviously charged with the time where they asked for one case to track another. So everybody was clearly aware that there were these 2 cases tracking all along, discussion of global plea, which is not unusual. So it doesn't sound like something that the people wouldn't have been aware of, so that at this last-minute 40th hour just happens to be around the time that they would get charged with a lot of time, they indicate that they have a motion for discovery. I mean, it even caused the court to say what I just mentioned, criticizing this last-minute change in strategy.
Well, I think that the entire record makes clear that both sides expected and were working towards a global disposition as the case was pending. Should the prosecutor have filed a motion to consolidate much earlier during that timeline? Probably yes. I mean, of course, there is a statutory deadline, and in this case, that the prosecutor.
So what you're saying is this had nothing to do with the fact that maybe the people hadn't had a chance to go over the record and come up with this, address the issue of a global plea, and that they were sort of caught flat-footed and did this instead so that the time didn't run?
Well, when the people filed that motion to consolidate, the court didn't necessarily have to allow an adjournment to entertain that motion. It could have summarily denied the motion right that day. That was a possibility, at least. The people filed a certificate of readiness the next day, and so obviously,
But it was that day. Once the motion was made, it stopped the clock.
right, that's true. And look, obviously, the people would have been aware of what the number of chargeable days was up to that point because there had been that previous speedy trial decision. So certainly the people were cognizant of that, but the people also, the record shows, were that they not only filed the motion to consolidate, but also were preparing to actually be ready for trial because they did file that certificate of readiness the next day. And I would just point out that when the people filed that motion before Justice Scherzer, the defense filed an opposition to the motion to consolidate and also filed filed their second speedy trial motion, and in that motion argued that the people's motion to consolidate had been filed in bad faith. Justice Scherzer had all of those papers before her, and yes, she criticized the people for filing their motion to consolidate after the deadline, but she, at the same time, didn't find that the motion itself was a sham or was frivolous or was filed in bad faith, as she could have. Thank you, Your Honor.
Thank you. You may begin.
Your Honor, I want the court to realize what a big deal it is that this judge not only ruled on the merits and the timeliness, but went out of her way to include language that this was an unacceptable strategic choice by the prosecution. And the record shows that they knew exactly what they were doing at the time they filed this. They had not stated ready in 2 years. They had told the court—
I don't know that the record shows that they knew what they were doing. I think the court said what the court meant. They should not change, be more on top of it, not change at this last minute. That's what the court said.
Yes, Your Honor,
There's
but—
nothing more on the record for us we can't,
Your Honor—
make things up about what's not here.
Well, Your Honor, they had explicitly told the court, as officers of the court, that they believed these cases were unrelated and they had no intent to file them. And this, as Your Honor noted, this case had been pending for 2 years. But perhaps more telling than that, Your Honor, it was so far past the statutory deadline that they were precluded. It's very common for lawyers to file motions that are late, but they didn't even try and excuse it. They didn't seek an extension. They didn't ask the court to still review it despite their blatant untimeliness. It was precluded. The judge was never going to review it anyway, but it didn't matter because it stopped the clock. And that's why it was filed, Your Honor. Thank you.
Thank you. Thank you both. Maria Duque versus 50 Clinton Property Owners, LLC. You may begin.
Thank you, Your Honors. Greg Friedman for the appellant. I'll try to be quick here. I'll start with this. So the trial court says in its decision that the fact that this fridge was elevated on a dolly is legally irrelevant. It's just not correct. It's specifically one of the 4 Soto factors, and obviously an important one.
Counsel, isn't the issue here whether or not your client was involved in routine activity, that kind of thing? I mean, your client was a cleaner, correct?
That's basically what this whole case turns on.
So then, again, wasn't the plaintiff involved in routine cleaning activity, not using special equipment? So under Soto, what's the case here?
Right, so you have the 4 factors in Soto, and obviously you have to balance them. It doesn't turn on whether she did or didn't otherwise need specialized equipment, but to speak to that, I think—
Well, what about routine? Isn't this just routine cleaning that she was engaged in?
Well, no, because whether it's routine or not depends on those factors, number 1 of which there was obviously a significant elevation-related risk here. We cited the case in our brief, basically involving identical facts where some large metal object falls off of a dolly, 240 was held to apply. Then we look at the other factors. Her employer is hired specifically in connection with basically a top-to-bottom gut job of the defendant's building.
But counsel, there may have been other work in other parts of the building, but this apartment was ready to go. There are sometimes other finishing work in buildings, but the apartments can still be sold and people can move in. This apartment was done, basically, essentially, it was no different than what one might find in a house where somebody delivers a refrigerator, or it was, so why should we look at this as a 240 case?
Well, the plaintiff was also doing post-construction cleaning the apartment, separate and apart from the refrigerator itself. And I think
Well, it's cleaning, right? It's cleaning. It's sort of like Morales. In Morales, the plaintiff is cleaning, I think, the tops of the cabinets and falls off the stepladder. This is essentially the same case.
I don't think it's the same. I mean, when we look at what this court actually emphasized in Morales, first it said at the time of the accident, give or take 90% of the units are already occupied. In this case, even if you say that the construction in this particular unit had been done, the project was far from over. It didn't finish.
But it was a
until
final
over a
cleaning,
year.
as in Morales. Wasn't it a final cleaning? Wasn't that the Soto factor that they focused on, the final cleaning? That's what this was.
I think that's what the label was. I wouldn't say that Morales focused on it being characterized as
Well,
a
wasn't
final.
this case a final cleaning? That's what she was told to go in there to clean. She was...
It was a final cleaning, yes, of that particular unit, but I think we're isolating the moment of the injury too much when the apartment had not, there wasn't even a TCO yet for it. It wasn't sold to an owner until I think
But does that matter? Does that matter? Isn't the issue whether or not the plaintiff's engaged in routine cleaning activity, was whether or not special equipment was being used, that kind of thing?
I think it matters because of what this court said in Soto, where it said at the time of the act, not in Soto, in Morales, where it said 90% of the units were already occupied. That obviously was considering the rest of the project, not just the particular apartment where the plaintiff was working. And I think when you compare this to Soto, which obviously still governs, the plaintiff there was part of the defendant's in-house maintenance staff. There was no other construction project going on, and he fell from a 4-foot ladder. Those are the facts the Soto court emphasized, and you just can't compare that to the facts here. I see I'm out of time.
Thank you.
Thank you.
You have 2 minutes of rebuttal.
Good afternoon, Your Honors. May it please the Court, Shanna Torgerson for the respondent. Looking at the total factors that are present in...
So this was on a dolly. It was a big refrigerator. As we know, refrigerators can be enormous. And it was strapped to the dolly, and the person unstrapped it.
Yes,
Big
allegedly.
thing. Teetering on the dolly?
To my knowledge, and in the record, there's nothing that indicates any sort of teetering and or movement. Yes, it had been strapped onto the dolly, and for whatever reason, someone removed it. But I certainly posit that following the ruling in the IAS court, they got it correct, that under the various factors in Soto, this was in fact routine cleaning. And let's say hypothetically that for one reason or another, it is not considered routine cleaning, which I argue it is, it still fits within the other 3 factors of Soto. And as that case specifically states, you don't need to have all 4 factors.
Are you done?
I am.
Okay.
Thank you.
Thank you.
Okay, Your Honors, I think I requested 2 minutes, but I probably won't need that long. I think the main points are already covered in our brief. I'll just say very quickly that any arguments about exactly how big the fridge was, how high the dolly was, aren't material. At absolute worst, it would just raise issues of fact there. And I'll just highlight one more thing, which I think is relevant, that the defendant's witness testified that it was the construction manager that supervised the delivery of the refrigerators to the apartments. So it just underscores that there was still some relation between APS's work and the ongoing construction project. And otherwise, when you look at the specific facts in Soto compared to those here, there are clear differences, even if the plaintiff otherwise wouldn't have needed specialized equipment. We're not saying she needed specialized equipment if the fridge was sitting flat on the floor. We couldn't argue that, but given the circumstances here, I think the other facts weigh enough in our favor to put it under protected cleaning. If there are other questions, I'll rest on the brief.
Thank you.
Thank
Thank
you.
you both. Alvarez versus Brashida. You may begin.
Good afternoon, Your Honors. May it please the court, Peter Morris, for the plaintiff's appellants in this case. We respectfully submit that there are issues of fact as to credibility and liability in this three-car motor vehicle accident.
Well, what negligent is there against Fernandez? It's 3 cars and Brashida, but what is there against Fernandez?
Against Fernandez specifically is whether or not in violation of the VTL he was following too closely. Fernandez claims that he was...
Excuse me, counsel, let's go back to what highway was this on?
This was on the Major Deegan.
And was there a lot of traffic on the Major Deegan at that time?
They indicated that it was heavy stop-and-go
And
traffic.
how fast were the vehicles moving?
15 to 20 miles per hour based on the testimony of the parties.
And for how long was Fernandez's car in front of the car behind it?
He indicated that it was there for a significant period of time. that
7
they were
minutes.
traveling.
7 minutes. That's not, so he's traveling behind the car for 7 minutes. And in fact, I'm not saying that the car stopped short, but he said the car stopped short previous
Well,
to
actually,
this occasion where he says the car stopped short and caused the accident. So it's something that he was aware of.
well, there's actually diametrically opposed testimony on this issue sufficient to raise a material issue of fact. Defendant Brachida says stop short, but Mr. Fernandez says, no, I never stopped short.
But
Okay,
the point is, this is from the defendant, the third car's perspective, and he's saying that he was behind the car for 7 minutes, that it already had stopped short, which now gives him full notice that the car, there's traffic, it may stop, and it stopped short, and he hits that car while the first car was stopped and was not hit immediately, was not hit before the third car hit the second car. Isn't that right?
That is correct, Your Honor. However, there are issues in terms of whether or not Fernandez was following too closely. He claims...
Well, he didn't hit the car until he was hit.
That is correct, but whether or not he was pushed is an issue of fact, because Brachida says no, he says yes, but the reality is that to have this benefit, you need to be properly stopped under the law. And he testified, Fernandez, everyone says, no, I stopped 5, 10 feet before the car. That is not supported by his testimony. I asked him at deposition, and he stated, at 5 to 10 feet, I started braking. Were you stopped or moving? He said he was moving. And at that point, I said, well, how long did it take you to stop? And he said, I don't know.
But counsel, didn't Brashuda's vehicle push the Fernandez vehicle into your vehicle?
That is an issue of fact because...
Based on
according to
what
Brachida-
evidence is that an issue of fact?
Because Brachida says it didn't move, and the photographic evidence, Your Honor, clearly shows 3 cars pressed up against each other. If, in fact, he was pushed 5 to 7 feet as claimed, the photograph would be middle car and plaintiff together with Brachida 5 or 7 feet away. But that's not what the photographic evidence shows. The photographic evidence supports Brachida's...
You got an expert to say that? You got an expert that backs that statement up that you just said that the third car would have been further back if there had actually been a push situation? Do you have an expert, a traffic expert, to say that that's would happen?
No, the only expert was provided by defendant Medley.
Right, I'm just going to what you
I don't
just...
no, I don't have an expert on
Because
that.
you're arguing that the third car, the photographic evidence of all 3 cars are together, correct? And you're saying that if there was an actual push situation, as the defendant here is claiming, Fernandez is claiming, that the third car would have been further back. It wouldn't have been all together. He would have been pushed and it would have gone forward, right?
Correct.
I got to get a traffic expert to tell me that, right? Because when it comes to traffic type of situation, we know with auto accidents, strange things can happen when things get hit, you know.
Well, strange things don't happen, Your Honor, when both defendants state that they are pressing very strongly upon their brakes. So the reality is, again, this is all issues to be addressed by the jury, not by the court, not by
Well,
defense
taking
counsel.
that point, you're saying that both defendants are saying they're pressing hard on the brakes. Yeah, you could be pressing hard on your brakes and your car could be still squished up against the front car. I mean, your brakes are on. It just, however the road surface is at that time, whatever, you're all together.
Well, taking into account.
And by the way, there's no question here that the third car hit the second car before the second car hit the first car.
That is correct, Your Honor. However, there is an issue of fact in whether or not the middle vehicle was violated of the VTL for following too closely, an issue of fact on credibility, whether he was pushed. He had a dash cam video that he claims.
You can finish that up on rebuttal. Thank you.
Fair enough. Thank you, Your Honor.
Good afternoon. May it please the court. Ryan Mainhardt for the respondent, Edgar J. Fernandez.
So counsel, what was Fernandez's non-negligent explanation for rear-ending plaintiff's vehicle?
His non-negligent explanation was that he was pushed by the Brachita vehicle into the appellants. And
What do you make of counsel's argument that the accident wouldn't have occurred if your guy had been further back? He was traveling too closely to plaintiff's vehicle.
well, let's entertain that thought, for example. Let's say that the lower court overlooked that and 5 to 10 feet stopped behind a front vehicle is negligent as a matter of law. You still have to prove proximate cause. And the proximate cause of this multi-vehicle rear-end accident was the Brachita vehicle rear-ending my client
But can't there
Fernandez's
be more
vehicle.
than one proximate cause of an accident, or you're saying that the Brachita vehicle is the sole proximate cause?
I'm saying that the Brachita vehicle was the sole proximate cause, but for his negligence in following too closely, the Fernandez vehicle never touches the Alvarez vehicle. And there's nothing to reverse here, Your Honor.
And your client says he was stopped at the time he was hit.
Yes, and there is a dispute as to whether he stopped gradually or suddenly, but the law does not differentiate between the two. The rearmost vehicle still has the obligation to maintain a safe distance and not rear-end that
How do you
vehicle.
respond to the argument that these cars were all together, all three cars were together, and if that doesn't make any sense, if in fact, if it was a push situation, the third car would have been further back?
I think you said it. It doesn't make any sense, and there are multiple reasons why that configuration could have happened. There is no expert testimony as to why. The photos capture a very specific moment in time where, yes, two vehicles are touching, one vehicle is not, but that's never determined when after the accident that occurred. It has no merit whatsoever. It's only probative on the issue of these three vehicles were in that alignment, and yes, an accident happened among the three. I have nothing further, Your Honor.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Andrew Thabeau. I'm here for the respondent, Medley Pharmacy. I am here on fully support respondent Edgar J. Fernandez position. Medley Pharmacy was Edgar J. Fernandez's employer at the time. I think what needs to be clarified and cleared is summary judgment cannot be defeated by a shadowy resemblance of an issue of fact. Let's first talk about the photos that Mr. Morris stated earlier. The three photos show from three different perspectives. All three cars are not hit together. As Mr. Mahar has stated earlier, you have two vehicles, the third vehicle and the second vehicle together, and you have the first vehicle far apart. These vehicles are post-accident. These photos do not explain the two critical issues in this case, which is whether or not Edgar J. Fernandez was following too closely behind the Alvarez vehicle, plaintiff's vehicle, lead vehicle, and two, whether or not he failed to stop. None of these photos that you see in the record from 527 to 529 does not evince any evidence or provide any question of fact as to whether or not there was any chance that Mr. Fernandez's vehicle was following too closely. And also needs to be clear, 1129A does not provide a standard or particular distance as to what is too close and what is too fast. At the end of the day, it's based on the conditions at the time. I think as all New Yorkers, we understand what is the major Deegan around 4 o'clock. It's bumper to bumper, and it's going to be 5 to 10 feet throughout the whole time, especially when you're going around Yankee Stadium. And it's clear, based on the conditions of the case,
We don't need an expert for that. That's what you're saying?
I think we
can
can all be
take
experts
judicial
in this, Your
notice of
Honor.
that.
I think there's no doubt that we all know that it's going to be bumper to bumper, less than 10 feet between each car. The idea that there was any expectation that any vehicle would have been more than 10 feet at the time is unquestionable, and which my expert at the time mentioned. And I think it also should be noted that there's no dispute as to whether or not there is any question of how fast, whether or not he was going to speed, whether or not it was negligent at the time. There is no dispute as to whether or not he was failing too closely. All parties agreed that there was a bang, then seconds later, there was an impact. His clients testified that, and they made that clear. Mr. Alvarez stated 3 seconds. 3 seconds. It is clear that from that time in those 3 seconds, 5 to 10 feet would have caused a collision. Mrs. Alvarez states in 170, it was 10 seconds. She was able to hear an impact, turn around, see her kids, then got collided. Based on that testimony alone, it clearly shows that Mr. Fernandez was stopped, and due to the stop, he was propelled forward, and that's accident 7, which shows that Mr. Brashida is the sole proximate cause. Thank you,
Thank
Your
you.
Honors.
Medley's own expert failed to address any of those issues, also failed to provide any empirical data on what his opinions were based upon. If we had the dash cam video, we would have known what would have happened. However, spoliation is an adverse inference.
What was the overriding of the footage? Was that willful in any way? Was there
Willful,
ever
no.
was there ever an
Request.
effort to put a litigation hold on those on the camera footage?
Willful, no. Negligent, yes, which is required. However,
How was it negligent?
it's negligent because he knew that there was an accident. He saw Mrs. Alvarez being taken away in an ambulance. He knew that there's a high likelihood of litigation going to commence. He had a duty to preserve. And when he tried to download, his credibility is at issue to say, well, it's not there.
So everything for you is credibility, right?
This is a huge
So
case
let's go
of
back to
credibility.
the question that was asked before, and that is, wasn't the rear vehicle the sole proximate cause?
The rear vehicle was not, because following too closely is a cause. Whether he was pushed or not pushed could be a cause. Whether or not he was 15, 20 miles an hour, whether that was reasonable could be a cause. The bottom line is my clients had no culpable conduct whatsoever, and that it takes two to tango. And in this case, it was both vehicles as an issue of fact that should be decided by a
Well, I think
Counsel,
we
if I
should
may, how could the dash cam show the distance between the vehicles? Because I was under the impression that the view showed only the rear hood and the car in front of him. So how would that assist you in determining the distance?
Well, the dash cam, according to Fernandez, the middle vehicle was facing forward, looking at the car in front of it, my client's vehicle. That could then give us a perception of what the distance actually is. And there would be an adverse inference against them in terms of the spoliation of that evidence. Again, raising an issue of fact that should be addressed by a jury, not on summary judgment. Thank you very much.
Thank you all. H.H. Trinity versus Smith Anderson.
Good afternoon, Your
Good
Honors.
afternoon.
Stuart Kagan on behalf of the plaintiff appellants, H.H. Trinity Investments LLC, Apex Investments, Viridia Holding LLC, and Viridia Apex Parcel 10 LLC, which I'll call for purposes of brevity here together collectively Hudson Capital. With respect, Your Honors, the lower court judge made a significant error in her decision, and this court should reverse for at least the following 4 reasons. First, the lower court erred as a matter of law when she determined that a conspiracy theory of personal jurisdiction is not viable as a legal matter per se under the long-arm statute, section 302, unless that individual defendant is present in New York State. That's what she held and stated in the record. That's a very troubling decision.
What was the tortious act committed in New York to give conspiracy jurisdiction under A2?
There were many tortious acts committed. So actually, if I could step back a bit, Your Honor. The tortious acts that were committed here were committed by the co-conspirator.
By Henderson.
By Hendrickson, that's correct, which provided jurisdiction both for Hendrickson and, since Hendrickson was an agent for purposes of conspiracy jurisdiction, over the defendants in this case under 302A1
Did the defendants,
and 302A3.
Counsel, did the defendants benefit from the, I guess, the acts Henderson committed in New York, the tortious acts?
Absolutely, Your Honor.
How did he benefit?
Absolutely, Your Honor. The defendants in this particular case are law firms. An individual lawyer named Mitchell and a law firm named Smith Anderson. Both those law firms charged and received substantial legal fees, both from the appellant's Hudson Capital.
Those in North Carolina?
That was in North Carolina, Your Honor.
So their
Absolutely.
benefit was in North Carolina, wasn't it?
Their benefit that they obtained was where they were located, but the injury and the damage that they caused was where the defendant was located, Hudson Capital, which is in New York.
You didn't sue Hendrickson, did you?
We did not sue Hendrickson, Your Honor. Hendrickson previously was sued, was subject to New York jurisdiction. He filed a battery of motions to dismiss.
All right, you're using that as the bootstrap for this jurisdiction. I thought that was one of your arguments, that he was in the other action, he was here, therefore everybody else can be here.
No, Your Honor, I'm not trying to bootstrap it. I'm simply saying Mr. Hendrickson has already, that issue has already been settled. He never even bothered to raise jurisdiction, I believe, as a defense in his battery of motions. But
wait a minute. I think that's disingenuous. Could in the other action, Henderson have even raised an issue with respect to jurisdiction? Wasn't there a form selection clause here?
With regard to Mr. Hendrickson, there certainly was, I believe, and a choice of law clause. So that is correct. But as we have alleged, and as the pleadings need to be taken as true for purposes of this motion, Hendrickson was a co-conspirator with the defendants here. The co-conspirators knew of Hendrickson's activities. Hendrickson acted within the state, and the defendants knew that his conduct was going to cause adverse harm within the state. The judge held as a matter of law that
Is economic injury enough?
I'm sorry?
Even if the economic injury was felt in New York, as you say, is that factor enough?
We don't rest solely upon the economic injury. Mr. Hendrickson came, and it's alleged in our pleadings in detail, came to New York State on multiple occasions.
And so he transacted business in New York, no question, right?
Absolutely, Your Honor.
But
yes.
How does the transaction of his business in New York, how does it relate to the claims of this case? What's the nexus between that?
Yes, Your Honor. CPLR Section 302 is the nexus, because CPLR Section 302 says, and I quote, as to a cause of action arising from any of the acts enumerated in this section, talking about general jurisdiction, a court may exercise personal jurisdiction over any non-domiciliary, that is the defendants here, or executors or administrators, who in person or through an agent, Mr. Hendrickson was their agent, and they transacted that, they committed those tortious conducts in accordance with him, connected to him through their conspiracy to cause actions that were felt within the state of New York that they knew and reasonably should have known were to have had effects within the state of New York.
Essentially, you are arguing just that there is some economic harm in New York, and that's really it.
Oh, absolutely. I'm saying that that is not the sole basis of it. That is part of the basis of it. But the main nexus that brings them here within the grounds of this court's personal jurisdiction are the agency, the acts of the agent. And what I want to...
But yet, what I don't understand, though, is that the claims you're raising essentially have to do with the lockout provision. All that was drafted in North Carolina. So it does seem to me that you are bootstrapping whatever Henderson's activities, transaction of business in New York, with the defendant's activities in North Carolina.
While we do say that the lookout provision is the main issue that ultimately caused harm, Mr. Hendrickson, through the various asset management agreements that he entered into with us, as well as his multitude of contacts that he had within the state of New York, including his physical presence, that causes these defendants to be personally subject to jurisdiction here due to their agency relationship and in the conspiracy that we have pleaded.
Thank you.
Good afternoon. May it please the court. Evan Krinick on behalf of the Smith-Anderson defendants. The trial court here correctly dismissed this complaint for lack of personal jurisdiction.
I have a question.
Yes.
Was Mr. Hendrickson the defendant's agent?
Of course not. Attorneys are agents for their clients. Clients are not agents for their attorneys. The whole idea of conspiracy jurisdiction, which certainly does exist in New York, is based on the rationale of agency. And here it's just backwards. The attorneys are not the agents of their clients. So the idea that the attorneys here were the principals and directed their agent, their client, into New York, just to say it shows you how backwards it is in this case. And we can get into the weeds, and I'm sure we will, but just fundamental issues of fairness, common sense, tell you that a North Carolina, hired by a North Carolina client, on a zoning dispute in North Carolina, giving advice about that in North Carolina, does not expect to be held into court because one of the owners of the property happens to have a principal place of business in New York. That's just common sense, that's just fairness, and that's where the law takes you, to that very same result, that really makes no sense. Conspiracy jurisdiction, if we're going to go there, if there was a conspiracy here, which I think is fairly speculative to begin with, but even if there was a conspiracy, requires awareness, benefit, and control as three elements this court has
So in
said.
this case, your adversary argues that Henderson committed essentially financial extortion in New York. Would that be a basis for conspiracy jurisdiction?
It might be a basis for a suit against Mr. Hendrickson, but it doesn't implicate the attorneys in North Carolina who had no basis to be aware that Mr. Hendrickson was doing in New York.
And did they benefit from?
And there's no benefit to the law firm. Earning legal fees in the normal course of your practice is not a benefit of being part of a conspiracy. There's a case, we cited the Bracewell case out of the Southern District, which directly addressed that and says an attorney who's earning fees in a normal course of the business and trying to develop a relationship with a client is not sufficient benefit to justify inferring a conspiracy. And most importantly, there's no control or direction here. The idea that the lawyers directed or controlled the conduct of Mr. Hendrickson certainly makes no sense in the facts of this case. So whatever control might mean in the case law, it doesn't mean this. It doesn't mean that lawyers can somehow be seen to control their clients' actions in New York when they have no awareness of it and no benefit from it. And frankly, if this is enough for control, which I don't think it even comes close, I think then you've got due process issues. I think you've got constitutional issues about personal jurisdiction if the standard is so loose that you can get personal jurisdiction over these North Carolina attorneys in New York on these set of facts under the long-arm statute. I think you've been very close, if not breached, the idea that there's a due process violation here. In no way that our clients avail themselves of the benefits of New York, so they should reasonably be expected to defend themselves in a New York forum. So I don't think it meets conspiracy jurisdiction, the elements, even if it is a conspiracy. I don't think it meets the jurisdictional requirements. And if it somehow does, I think we've got constitutional problems. So for all those reasons, I think the Supreme Court correctly dismissed this complaint.
Thank you.
No other questions? Thank you.
We have, yeah.
Good afternoon, Your Honors. Ryan Donovan for Respondent Mitchell. My co-counsel and I, arguments are very similar, so I will cut mine down significantly, not to waste your time. What was asked of the appellant during his initial argument wasn't really answered. What acts bind this, quote, conspiracy, which I do not concede, but for sake of argument, what acts of Mr. Hendrickson in this jurisdiction was an overt act of the conspiracy? It was not answered. It was sidestepped because there were no overt acts. The overt acts alleged of this conspiracy are establishing the lock-in provision, the responsible person, the lock-in provision in the Sustainable Development
The
Plan.
alleged extortion that Henderson committed in New York.
What documents are there to establish there was any extortion? Not to get into the weeds, Your Honor, but to answer your question directly, they have the burden, once we challenge personal jurisdiction, to submit documentary evidence, some type of evidence establishing that the overt act even occurred. All it is an allegation. That's not sufficient when personal jurisdiction is challenged. So I don't know because we haven't been told. There's no evidence to establish that extortion occurred. There's just an allegation. To allow the plaintiffs, which are 3 LLCs formed in other states, sole purpose to operate a property development project in and outside of Raleigh, North Carolina, dealing with North Carolina law, North Carolina activities, and North Carolina lawyers who had no reason to believe they would ever be dragged to this court or this jurisdiction. What basis would they have to believe that they could have to come answer a lawsuit here when everything in this case had to deal with North Carolina, but for the parent company of the 3 LLCs? At this time, I'll rest on the brief, and I appreciate your attention.
Thank you.
The record at page 405 and subsequent documents squarely contradicts virtually everything that my colleague indicated for Ms. Mitchell. He indicated to your honors that there were no documentary evidence, no evidence put forward on jurisdiction, that everything was on the basis of allegations. I just heard him say that. That's not true. It's quite false. There is an affidavit sworn to by David Liu, one of the individuals who is with appellants, who put in the record below a detailed affidavit with a series of exhibits which the court will find at the record from pages 405 and forward, discussing all of the issues regarding extortion, not just the creation of the lookout provision, which one of your honors talked about earlier, but the extortion.
But again, counsel, assuming all that,
Yes.
assuming all that, but you still haven't shown how the defendants benefited from the extortion in New York. They're in North Carolina. How did they benefit from that other than legal fees? Your adversary has a good point. You folks are earning legal fees. A lot of people in this room are earning legal fees. That surely can't be considered a benefit.
Because they were disloyal and they had 2 clients at odds with each other. This is not a case of regular legal fees at all. Recollect, please, what Smith Anderson did here. Lacey Reeves, a partner of Smith Anderson, worked covertly with Mr. Hendrickson while they were lawyers for the appellants. They were our lawyers. Hudson paid them. Hudson paid them to work on the development on their behalf.
Shouldn't there be a legal malpractice claim down in North Carolina then?
I'm sorry?
Should not that be a legal malpractice claim down in North Carolina if they were disloyal to your client?
I am not a lawyer authorized to practice in North Carolina, so while I have opinions on it technically.
We have people pro hoc vice here all the time.
That's right. So what you, just jumping off of what you just said, if they were disloyal to your client, if they represented 2 clients, that's a legal malpractice claim that should be down in North Carolina.
So that may be, but I do not believe that simply because they might have had an option to do that, that they are not precluded from bringing this claim here. And the benefit that they received, just to be clear on it, and I will conclude with this, is that Mr. Hendrickson was working with them to benefit both him and them, and they were getting paid to lock out my clients while they were purporting to be our attorneys. That I will conclude.
Thank you. Thank you all. People versus Carl Smalls.
Good afternoon, Your Honors. Delorny Moran for Appellant Mr. Smalls. Mr. Small asked this court to reduce his prison term by 1 year in order for him to receive immediate mental health treatment on post-release supervision. The record in this case makes clear that Mr. Small's mental health diagnosis at least contributed to the conduct at the time of the offense. Furthermore, Your Honor, that conduct was an aberration. Mr. Smalls has been diagnosed with severe mental illnesses for approximately 40 years, yet this is his first violent felony. We do acknowledge that, Your Honor, Mr. Small, who has severe mental illness and is homeless, does have a large number of misdemeanors, Your Honor, and also has 2 prior robberies, one from 1982 and one from 2004. There is no appeal waiver in this case, Your Honor. So therefore, when this court considers whether an whether a sentence is excessive, there's a delicate balancing act between the special circumstances, in this case, Mr. Smalls, and the penal goals, which is societal protection, deterrence, and rehabilitation. I do believe, Your Honor, a reduction of his prison term, which will allow him to receive the highest level of mental health supervision on post-release, will address both of those goals, Your Honor. Mr. Smalls will receive mental health.
Are you saying, yes, okay. If you would just explain what you just said about the highest level of treatment.
Yes, Your Honor, Mr. Smalls' diagnosis is schizoaffective disorder that is clear in the records, including in his pre-sentence report. Therefore, Your Honor, he and docs is receiving mental health treatment and is considered by the Office of Mental Health a level 1. Level 1 meaning schizophrenic, bipolar, people of those type of diagnosis. And therefore, when he is released on post-release supervision, docs will then have to ensure that he has supporting housing and that he has mental health treatment that goes to the supporting housing, given the fact that it is clearly document of his mental health treatment. It would be like a continuation from what he's receiving in prison, which my client is receiving mental health treatment in prison right now.
So I just want to ask, now, wasn't the court aware of the defendant's mental illness? Because in fact, the court undercut the people's offer of 12 years, correct?
Yes, Your Honor. The people asked for 12, the defendant asked for 8, which would be the legal minimum here, and the court at the time gave 10, Your Honor. We do acknowledge that there was an undercut, but we do, as you guys are well aware, you guys are allowed to review negotiated pleas, especially in this case where there is no appeal waiver that bars that. Your Honor, the additional 2 years in prison will not at all deter anything. Some of the symptoms that were manifesting on the date is hallucination and paranoia ideation. Further years in prison is not going to at all solve any public safety concerns. What Mr.
I'm sorry. I just wanted to get back to one thing that you said about the level of treatment that he would receive. Are you saying that by reducing his sentence by 1 year, he's going to get better treatment on the outside? That's what I was asking. And I'm not clear on what you were saying.
Sorry. Yes, Your Honor, Mr. Smalls will get
level 1 treatment, which is the best treatment? Is that
yes,
what you're saying?
in his.
And what level would he get now if his sentence wasn't reduced?
Well, Your Honor, he would have to wait to be released in order to receive that treatment. So that,
right, I understand, but once he's released, won't he still get that level 1 treatment?
Yes, he would. He's always entitled to the OMH level 1 treatment upon release. Our position, Your Honor, is that an additional year in prison is
not going to make a difference in terms of helping his mental condition.
Exactly, Your Honor, and we do believe that this is a special circumstance that will entitle this court in their balancing act to reduce the sentence as it balances in favor of a reduction.
What assurances are there that Mr. Smalls will actually participate in these level 1 treatments?
Your Honor, yeah, because he's ordered to do so.
I know that, but I mean, I understand that he's ordered to do so, but what happens if he doesn't?
He goes back to prison, Your Honor. He would be in violation of his post-release supervision and would therefore go back to prison. And as the 730 report states, Your Honor, and the forensic evaluation, Mr. Smalls on medication is compliant at the time of the offense.
Right, so your argument to, at least in my mind, is that, I'm going to have to then believe that Mr. Smalls will participate in the level 1 services and actually make sure that he gets help for his mental issues, correct?
Yes, Your Honor. I just want to, he's, at the time of the offense, Mr. Smalls was 50 years old. He had already spent 40 years in the community and not committed such an offense because he had been in compliance prior to the offense.
So just one thing. Okay. So he did not, you're saying once he's released, whether it's without a reduction or with a reduction, he is going to have someone who is providing supportive housing?
Yes, Yes, he's entitled by legislation.
And when he was out before, when he committed this offense, he did not have that?
He was not on any form of supervision at the time, Your Honor. He was just a homeless person in New York City.
Yes. Okay, thank you.
Good afternoon, Your Honors, and may it please the Court, Katha Murata for the people. Defendant's sentence was fair and appropriate and should not be disturbed on appeal. All of the factors referenced by defendant were already well known to the sentencing court, and Justice Ward took them all into account when fashioning a sentence only 2 years above the minimum. By pleading guilty to attempted murder in the second degree, defendant faced a maximum term of 25 years. However, in the court's discretion, Justice Ward sentenced defendant only to 10 years, which was 2 years below what the people requested. Here, defendant committed a very serious offense, shoving a stranger into the side of a train.
What's your response to counsel's, argument that, a year is not going to make a difference, and if, in fact, if we let him out or we release him now, he'd get the level 1 services instead of, a year now or a year later,
I think it's important to note that according to the defendant, he was taking his medication at the time of the offense and was seeking monthly psychiatric treatment at Bellevue Hospital, and yet he still committed this offense.
For that matter, on that basis, you should keep him in for the rest of his life. I mean, he was 50 years old, and he wasn't without offense, for sure. But committing the act he committed was, well, even aberrational for him. Just didn't happen. In the 50 years, that's just not what he did. So that's really, and he was not on any sort of supervision, as was stated. So he wasn't monitored with regard to housing, with regard to treatment, with regard to all of those other things in a way that could put him back in jail.
Your Honor, I think over the course of his life, he has an increasing escalation in violent behavior. He was convicted of robbery in the second degree in 1982, robbery in the third degree in 2004, sexual abuse in the third degree, this instant offense. The Department of Corrections stated that defendant was a habitual offender whose violent capacity
Is increasing? Is that the idea?
Yeah, is increasingly violent criminal.
When he's on medication?
He stated that he was on medication at the time of the offense and still committed this violent offense.
Well, I don't think that's what the psychiatric reports indicate based on his behavior.
That admission is on the page 5 of the pre-sentence report from May 2017 about taking medication. He admitted
his
that.
Statement.
Defendant's statement saying that he was on medication at the time of the offense and was seeking monthly psychiatric treatment from Bellevue. That's on the PSR on page 5.
Did anybody compare that to actual records from Bellevue?
That I am not sure, Your Honor.
That's what I'm talking about.
Okay. As far as that, I think the near minimum sentence that Justice Ward imposed struck a balance between defendant's well-known struggles with mental illness, and his violent behavior. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Your Honor, I do just want to add, as to the pre-sentencing report, there were a lot of statements in the pre-sentencing report, Your Honor, that even at sentencing, the court did ask the defendant, for example, the defendant stated he didn't do it, and then clarified at sentencing that he never made those statements. I think even the 730 doctors state that on medication, it's not that he's asymptomatic, it's just that those symptoms are diminished. As you alluded, the Bellevue records are clear that Mr. Small wasn't on medication at the time of the offense, and Bellevue Psychiatric does have repeated relations, as the forensic report states, with Mr. Smalls, as he's regular in New York City public hospitals. Hearing no further questions, thank you.
Thank you. Thank you both. Little Cherry versus Cherry Street. Justice Oing is recused from this case.
May I start?
Okay.
Okay. Good afternoon. I'm Paul O'Connor for Appellant's Cherry Street owner and JDS Development. All this case concerns, and I think this is important, all this case concerns, although the trial court's order goes much further than that, quite wrongly, is
So
whether
let me ask you, in the prior appeal, because I think that's what in the prior appeal, Didn't we already decide this threshold question about whether the plaintiff and the mortgage company were parties in interest?
No, Your Honor, I think that was my first point, and I think the key point here. That issue has not been decided. If you look at what this court said quite clearly, and in its order, was that in order for them to be an interested party, they were going to need to show, and I'm now quoting, that they quote-unquote could meet.
Okay, but that's not the holding of the case. That's dicta. I mean, there was a re-argument motion here where I imagine you told the court, you said could. The court came back with the same conclusion that they were parties in interest.
Well, I don't believe that on reconsideration the court held that they were parties in interest. What the court did was affirmed its prior decision, and what the prior decision said was that there were allegations in the complaint that quote could meet the parties in interest requirements.
That's just taking two words respectfully out of context. The paragraph starts, defendants failed to establish as a matter of law that plaintiff is not a party in interest whose consent is required for zoning merger. Isn't that, as my colleague is suggesting, that's the holding? And isn't that what we are bound by? That's the law of our case, right?
Well, no, I don't actually think that is the law of the case, because I don't actually think that's what this decision says. I mean, I think what this decision is saying is that it's the opposite, that we did not demonstrate that they were not a party in interest. They need to now demonstrate that they are a party in interest. And in order to be a party in interest, they need to be adversely affected. And there were absolutely no showings.
Let's just go to the merits. They're not adversely affected. My recollection of the record is that the building is cantilevered over onto their property, correct?
Well, one plan of the building would be, there is no building there now, but one plan would be that it would be cantilevered over, but there was absolutely no
So let's assume that's the plan that you're going by. That doesn't adversely affect the adjoining property?
I mean, Your Honor, there's absolutely no evidence in the record here at all as to precisely as to what impact at all would be felt by any of these folks.
Just that, loss of sunlight, no?
They don't have a right to those things?
I don't believe, Your Honor, I don't believe there's any showing that there's going to be a loss of sunlight or any impact on them at all. This is all supposition. Again, I come back to what this court said in the last time I was in front of you on this appeal, which is that they made allegations that could meet. It was their obligation to then come in front of the trial judge and put on evidence. They didn't. The trial judge went on the assumption that simply because of their position, they were parties in interest. They need to show that they were adversely affected. They did not show that they were adversely affected. And absent a showing that they were adversely affected, summary judgment is inappropriate. If they want to bring on some evidence to demonstrate that they were adversely affected.
So you're hanging your hat on the fact that this is not law of the case, that they are parties in interest. I want to be clear.
I am definitely hanging my hat on the fact that it's not law of the case, and I, again, am hanging my hat.
So your issue rises and falls on that.
Well, I've got more arguments to make other than that, but on this one point as to whether that
you should move on to the other one then.
Well, I'm going to move on. I will, Your Honor. The other points are, again, waiver. There was a Zelda and then a waiver.
Who were the parties to Zelda?
Pardon?
Who were the parties to the Zelda?
They were the prior parties in interest to the respondent here.
Wasn't it the owner in the Zelda, the air rights issue? Wasn't that the owner as opposed to the plaintiff here, who's the lessor?
Well, but they have a unity of interest, Your Honor. I mean, I don't think the issue is, as I understand it, that was done to the trial court, is that there was in fact there wasn't a waiver. Not that that waiver wouldn't impact this plaintiff.
Well, the waiver I think is separate than the Zelda, right? I mean, you're talking about the 2008 waiver, and that was only with regard to lots 76 and 15, as opposed to this lot, which is 70.
Which is lot 70,
and so they had only waived with regard to these plaintiffs, had only waived with regard to lots 76 and 15.
But again, it talks, there's language in the Zelda about 76 as it may be expanded. And that's what's happening here. What's happening
Are you referencing the recital now? Is that correct?
Correct, I'm referencing a recital.
And how are we to interpret a recital when interpreting the documents?
What you to do with a recital, it's certainly not clear that you're to disregard it, but absolutely it's clear that what you are is to use it to try to guide what the rest of the contract means. And it certainly is indicative of the fact that 76, as expanded, and again, I come back to the trial court. The trial court refused to take our expert evidence in, which was compelling evidence about the nature of interpreting Zeldas, because Zeldas are not uniform. They are unique to particular properties. And we had an expert who was going to testify, but the testimony was ignored by the trial judge, as a matter of fact, rejected by the trial judge and refused to be considered. I would like to make...
So in other words, contract interpretation now should be guided by expert testimony, is that correct?
On this issue, yes, I believe the court should have heard expert testimony and not simply issued a summary judgment order. There is one last point I would like to make. I know the red light's on, but I would like to just direct the court. We also believe that the injunction that was entered in here is extraordinarily overbroad and vague. This is an injunction which, to be honest with you, the respondents can't even agree amongst themselves what the injunction means.
I'll let you finish up on the injunction on rebuttal. You've given them a
Thank you, Your Honor.
notice of it.
Good afternoon, Your Honor. Scott Mullen on behalf of Little Cherry LLC. The questions indicate how well this court has reviewed the record. This case could be summed up in one sentence, actually, and that is, where's the waiver? Where is the waiver? The law is clear, based on the zoning resolution, that it requires a written, explicit waiver.
So, Mr. Mullen, you're right on that. You know, where is the waiver? There is no waiver. There was only a waiver as to 76 and 15, but they did consent to 76 and 15 being merged. What's the difference with this extra lot, lot 70?
Very simple, Your Honor. And first of all, I might point out that one of the cases that we think is right on point was a case that you sat on, Your Honor, the DLJ mortgage case, where someone had consented to or waived their right to purchase mortgages multiple times. And what Your Honor held was that each waiver was a discrete act. And because somebody waived their rights multiple times before, when they had the opportunity, doesn't mean that they're bound to waive it going forward. So that's precisely our position here. If one looks at the 2008 waiver, there is no word that talks about further expansion. There's no word in that waiver.
Your adversary would say then you'd look to the Zelda and then the recital B, which would give some indication of that.
I heard my adversary.
I'm sure you'd know it better than I do, but are the documents connected in any way?
First of all, as Your Honor, Justice Singh pointed out, we were not a party. Let's start with that. And the case law says you cannot waive if you are not a party. And if you look at this elder, it does not have the explicit waiver on our behalf. No one did it as our agent. No one purported to act on our behalf. We were simply not a party. And if we were not a party in interest, first of all, this court, these are the words of this court. Only a few years ago, a ground lease tenant has an interest in a tract of land akin to a fee owner. And with respect to no evidence in the record about adverse impact, the ground lease is in the record. The ground lease gave the tenant the right to demolish, to build, to modify. So clearly, the court found it had basis for saying there's a per se adverse impact. That was before the appellate division, and their brief indicated that that was the key issue. And then when they lost before this court, they then gave this court a chance to get it right in their eyes. They moved
As I said, there was a re-argument. They lost re-argument. Yes.
They lost re-argument. And if one looks at the emails in the case, in the record at 1450, that lawyers understood the sole issue remaining was waiver. Was there a waiver? There is no waiver. No writing, no email, no memo, no letter, no document. And the 2008 document, the waiver in 2008, was recorded by the city. It was adopted by the owner, no objection from the owner, no objection from anyone, and all of a sudden, they transformed somehow from being a party in interest in 2008, when it came to the time when they couldn't make a deal with my client, all of a sudden they're challenging again for, this is the fifth time, whether they're a party in interest.
Counsel, can you address before your time is runs out, the issue with respect to the breadth of the injunction. Your adversary says it's overbroad, they can't develop the property. Is that correct?
Yeah. The position of my adversary as to the
Injunction, the-
alleged overbroad injunction is
Yes.
incorrect because the court carefully tailored the scope of the injunction to the development that was set forth in the complaint. It was a specific development plan. The plans filed with the New York City Department of City Planning, specifically incorporated our lot, Lot 70. And the whole development required Lot 70. And the only thing the court did is say, you can't follow that particular development plan.
So in other words, they can develop their property as long as it's not of the merged lot.
The 2008 documents that they filed contemplated a development of a 122,000-foot building. They have plenty of options to build, develop. They just can't develop based on the rights attached to Lot 70. That's the only thing the injunction did. Thank you for your patience.
Good afternoon. May it please the court, Sumit Patel from Cullen and Dyckman on behalf of intervener respondent, New York Community Bank. Even if all of the prior court orders in this case were not enough, the parties actually charted their own course in litigation here, and it's important for this court to remember that. We have an email from appellant's attorney on page 1460 of the record confirming that the only remaining issue was whether the waiver signed by Little Cherry resulted in a waiver of objections to future mergers. All parties agreed to that and to litigate according to that email. That email actually sets forth all the material terms of what was being stipulated to at the time, and it is authenticated and subscribed by appellant's counsel. With that email, given how the parties charted the course of litigation here, even their new argument that the injunction is overbroad should not be considered. Appellant's attorney was fully aware of the relief being sought in the amended complaint, and even then, he did not maintain that there remained any issue with regard to the scope of the injunction. Nevertheless, arguing that the injunction was overbroad or that the zoning resolution permits this assemblage under these circumstances, that would put a complete stop to ground lease lending because no lender would undertake the risks associated with this once waived, forever waived theory espoused by the appellants. The need for certainty and predictability in this type of scenario is critical for economic development. Now, determining whether the scope of the injunction is proper, it's not a purely legal issue, as the appellants have maintained. The cases they rely upon are those that involve consideration of defenses, such as statute of limitations, condition precedent, lack of standing, issues like that. Those are clearly purely legal issues. But here, there's no question that an injunction is warranted. However, the argument that it's overbroad necessarily requires this court to engage in a fact-finding mission to analyze the extent or degree of the injunction. Appellants admit this on page 5 of their reply, where they maintain that there needs to be a determination as to what level of variance from the pre-application statement should be applicable. Allowing them to interject this argument now for the first time would prolong this litigation for years, because even if this court were to redefine the scope of the injunction, appellants would continue to argue that it is still overbroad. That is precisely the scenario that law of the case doctrine seeks to avoid. Now, finally, I would say that acceptance of appellant's argument on reply that NYCB's rights are somehow reliant upon Little Cherry's rights, and that if Little Cherry is deemed to have waived its rights, then so is NYCB, would necessarily eradicate the framework set forth in the zoning resolution, which provides that the ground lease mortgagees are indeed parties in interest. And this is because there would be no need to seek any waiver from them in the future. This would have a chilling effect on ground lease lending. Thank you.
Thank you.
So, counsel, your adversary says no issues with the injunction. You're perfectly free to develop your property in the manner you see fit in compliance with laws. You just can't do it on the merged property. What's wrong with that argument?
What's wrong with that argument, Your Honor, is that is not what is set forth in the injunction. The injunction
Well,
is
it talks
quite
about the
broad.
stern development, doesn't it? I mean, the injunction, what it does, it says you can't proceed with a stern development, but the stern development would require an expansion of the combined zoning lot that includes lot 70. That's the one that all this is about, not about lots 76 with 15, but lot 70 being included in that. The whole thing we've been talking about.
There's a paragraph in the injunction that speaks to there being no development, period, end of report, lowercase d, is one point. The second point is that, and again, the trial court refused to take this evidence, but there is evidence that it is possible to do what was going to be done at this site without the need for there to be a merger of these zoning lots. So the only
I'm sorry,
issue,
what did you just say? It
I
is
said
possible? Yes.
it is possible. There is a concept in the law known as assemblage. It would be possible to do this without the need for there to be a zoning merger. The only thing this case was about was section 12-10, and that is the need to get consent for a zoning merger.
Well,
that's what the injunction should have been focused on. Again, I don't think the injunction should have been.
Counsel, I have another question.
Sure.
Can you respond to the arguments of both counsel that you're now changing course after previously indicating that the sole issue was going to be whether there was waiver of further lot expansions, I believe, or mergers? Can you address both of those arguments?
Sure, Your Honor. That came about after litigation and hearings in front of the judge, who indicated that that's what she was focused on. And again, I know I'm pushing a rock uphill here, but I don't believe that it is law of the case, and I don't believe it's the law that they did not need to show adverse effect. But the trial judge was not going to hear evidence on that point. So the only issue that she was interested in was the issue of waiver, and I think that's very obvious from her opinion. And again, I come back to, I don't believe that the issue of the nature of an injunction is a legal one. We can argue it here on appeal, and you can see there is obviously a disagreement even amongst the respondents, and if you look at the piece of paper that the court actually entered, it's not consistent with what's being said here. If I leave this courtroom and we leave this process here and we don't get an order clarifying the injunction, I'm not sure how much reliance my client can be put on the statements that were made at this lectern by these two counsel. The fact of the matter is that the injunction does not focus as it should focus, if I'm wrong on my other points, simply on enjoining a merger of the lots absent consent. There are other ways to do it, and they should not be able to stop development at these sites, period, end of report. They don't have an interest in that. Again, it's a stick-up, it's a hold-up in order to try to get consent for something they don't have any right over. And again, the case has a long and littered history. Obviously, we had a motion to dismiss, then we came up on appeal, then we went back down. Then we had a hearing, we had a motion for summary judgment and a hearing on that.
I just want to be perfectly clear about something. When you are talking about this injunction, you are saying that development on lot 76 and 15 are also, there's no ability to proceed with development on 76 and 15.
What I'm saying, Your Honor, I didn't mean to interrupt you there, but what I am saying is that there is a lack of clarity in the injunction. That was not an issue in front of the judge. The only issue that was in front of the judge is whether or not we needed to get consent from them in order to merge the lots. And if there's going to be an injunction, that's the only injunction there should be. There should not be anything stopping them from doing the developments that my counsel over here says is all apparently fine on 15 and 76. And whatever they're allowed to do on 70. The injunction is overly broad and vague, and I think is invalid as a matter of law.
Well,
and not
whatever they're allowed to do on 70 is that it can't be merged with 76 and 15, but I'll...
If that ultimately is the conclusion of this court, the only injunction that should ever enter here is one that would stop there from being a lot merger that would require, absent their consent.
I think that's what I heard from your adversary, quite frankly.
Well, and again, I would urge the court to take a look at well, I'm sure you will take a look at the injunction and the language that the court used, which I think is completely inconsistent with the complaint, the relief that was sought, and the testimony and argument that the court heard. And with that, I'll sit down. Thank you.
Thank you. Thank you all. 5 Star Electric against MTA.
May it please the court, counsel, my name is Jim Barriere for Appellant 5 Star Electric with the law firm Hinckley, Allen & Snyder. The CDRB decision that was reviewed by the court below was written by an MTA employee on a $167 million signalization project between my client and the MTA New York City Transit Authority.
So let me just sort of get to the, what I think is the kernel here with regard to this no damages for delay clause and the enforceability of that. The CDRB
Yes.
Has said that it doesn't, it applies. The no damages for delay clause applies. And, it's your burden to show that there's no rational basis for that. So I'm going to ask you if you could just, get to showing us how there is no rational basis for the CDRB to have determined that the clause doesn't apply, given that these delays were contemplated in the contract, and also given the bases under the Court of Appeals Carino and Civetta.
Yes. Okay, Your Honor, the contract absolutely has a no damage for delay clause in it, and the Court of Appeals in Carino Civetta has recognized certain exceptions, one of them being whether or not the delays were contemplated, okay? So the first point I want the court to consider is this. Under Section 2.05 of the contract, the TA will not grant an extension of time unless the delay is unanticipated. Now, the one thing I'm going to tell you right off the bat is that on a project of this size with a 53-month duration, when all these authority services are required, you got to close the tracks, you got to get flaggers, you got to get work trains, you absolutely need to contemplate there's going to be some delays. It happens all the time on New York City Transit projects. However, this case is different because of the extraordinary delays. That weren't delays. They were wholesale denials.
Counsel, I'm listening to what you're saying, but correct me if I'm wrong, but how this all played out is that you got extension of time. You weren't penalized, right? You're looking for delayed damages on your part. I mean, lost opportunity going somewhere else because you were stuck on this job because you had extended, like, I don't know how many months or years, whatever. Your client lost the opportunity because I'm stuck on this job. I still got to work here, and I expect you now, the MTA, to pay me for that.
Mm-hmm.
I'm not so sure the contract allows that kind of recovery, right?
Couple of things on that,
Judge. Just cut right to what you want.
Yeah, if I may, and I'll get to what Justice Rakauer said at oral argument. She acknowledged that early on we complained, we're not getting the services, we're stuck on this job, right? She acknowledged correctly that we asked for a time extension. Here's where the rubber meets the road. We asked for the time extension early on in the project. We don't hear anything from Transit until 2017. We are now working under the threat of liquidated damages for upwards of 3 years.
You're held to the deal. You cannot move off this deal. You're stuck on this deal.
Stuck.
Exactly right. So you're looking now for the MTA to pay you for opportunities that you had to give up because you couldn't go anywhere
Not
else.
only the loss of the opportunities, but the increased cost of performing without all of this stuff.
Does this contract allow for that kind of thing? Because when you go into a contract with the MTA, everybody knows that those contracts are not going to be drafted for the contractor's benefit.
Right, and everybody also knows, Judge, that there are exceptions to no damage for delay, and they apply when they're uncontemplated. The TA agreed this was an uncontemplated delay in 2 ways. First, they gave us the time extension, and you can't give us one unless you agree. If I may, Judge, the second point is, in their papers to the CDRB, and I quoted in our brief, they said there was no way for us to know the impact on Hurricane Sandy on our ability to provide these services. This court has already found Hurricane Sandy is an unforeseeable, uncontemplated event under the Hernandez-Ortiz case, which I cite. This case falls within the exception, which is why the MTA employee said, I got to say...
I'm sorry, counsel, was this contract entered before Hurricane Sandy or shortly thereafter?
It was awarded before. It was entered into after.
I have a recollection, and I assume everyone does, the impact of the storm on the city of New York.
Yeah, may I discuss that?
Sure.
So, okay, so it gets awarded, well, I'm sorry, it's bid before, it's awarded after, just to be clear, okay? And then a year later, because under the contract, Five Star has to develop a resource-loaded schedule. They have to basically say to the MTA, okay, here's what we're going to perform, here's when we're going to perform it, here are the resources we need from you to get it. That occurred a year after.
In November 2013, is that when you're saying that that's when it took place, and then they had already begun to prioritize their resources to send to other places?
Yes, and that gets to the second problem. The second fact that was missed. The first fact was all the parties agreed it was uncontemplated. That's why they
You're
gave us
getting to the willfulness.
The second one is, well, not so much willfulness, Judge, but the superior knowledge component of this, where the CDRB flat out, this employee of the MTA flat out said the TA doesn't have superior knowledge of its available resources. Hold on a minute. You were telling the Capital Program Oversight Committee for the MTA for a year that your resources were completely shot because you had over $80 million in corrective work to do due to Sandy, and which ended up in the billions, candidly. So, I mean, the finding isn't supported. He said there's nothing in the record to support the finding. We put all the CPOC reports in the record to show that the finding was well supported. And I'll save the rest for rebuttal because I don't want to go over my time, but I do have some procedural points to make as well, if I may.
Okay.
Thank you, Judge.
Good afternoon, Your Honors. Lilia Abramchayev for the respondents.
I'd like you to pick it up from where counsel just ended with the superior knowledge and the fact that the TA in 2013 approved the schedule, but at that point started to gather information that made it aware that it would have to send its workers to other places, and that just kind of increased over the next couple of years, that knowledge and awareness that they were taking people off of this job.
Okay, so there was no prior knowledge or awareness at the time we were approving their schedule that we will not be giving them resources they were asking for. So a TA approval of a contractor.
I'm talking about in November 2013.
In November 13th, so which is about a year after the award, which is about a year after Sandy made landfall in New York.
You're saying at that point, the TA had not begun to prioritize its resources to repair the massive damage?
We were going to repair, however, there was a stage of assessment of damages and how much resources were going to be needed elsewhere in the system, including this project. All of our projects have priority, that's why they are being awarded. So Sandy had hit, it caught us off guard just like it did everyone else. And the fact that the TA approved five-star schedule means that we are taking your expertise on this. You know what needs to be done on the project. You know how long it will take. So the approval means nothing other than we have no objection.
The question I have is that this is not a situation where the MTA slapped Five Star with damages or liquidated damages because they didn't complete their project, right? I mean, this isn't that case. My understanding is, I'm just trying to get it, it's very straightforward, is that they're looking to get from the MTA damages as a result of the delay. They're looking for damages from you.
Absolutely.
And maybe I missed something in the contract because contract's always so thick. Where does it say that the money runs from the TA to the contractor?
That's exactly the proper way to look at it, Your Honor. Yes, the contract has a no damages for delay, which we do have damages for some delay. We specify them in Article 207, but there is no damages for this particular delay. The extension of time was excusable for unanticipated delay.
You gave them the time to finish the project. The time was given to them to finish the project.
The time was given to them.
You were not going to hold them responsible for the delay.
Absolutely. There were no liquidated damages assessed in this project. So all the extension does is it extends the substantial completion date, which is a contractual date.
There's no provision in the contract that provides that if the delays are the cause of the MTA, that somehow the contractor is going to get damages as a result of that. I don't
Absolutely. There are provisions to the contrary that no failure on our part to provide these TA services, which is general orders diversion of revenue service, they cannot form a basis for any claim for delay. It's specifically in the contract, in multiple provisions, in 207, in specification 1D, which is manner of prosecution of the work. They're all quoted in the brief, and I can direct your honor to them. It's right there. We cannot set these contractual provisions aside. They are in the contract. They do benefit the authority, but we pay for them because the bids are based on the terms
So
of the
the
contract.
answer to my question is that you did not have any special knowledge, superior knowledge. The knowledge you had was not to the level of superior knowledge as meant within the exceptions.
Exactly, Your Honor.
And this contract is based the way it is to protect the TA.
It is based to protect the TA.
Which is why so many of these sections are, so many of these things are included within this.
Exactly. Overarching priority of the TA is to run revenue service. So everything becomes subject to that.
Thank you.
Thank you.
Give me the specific contract provision that gives you the money.
I can't.
Okay, all right.
The note, if I may.
Okay, then I would
The
like,
no
where we-
damages for
where we
delay.
when we ended off, I want you to tell me why the no damages for delay is trumped by what you're saying is their special knowledge. I mean, how is that in a contract like this?
Your Honor, I am constrained to respond to the judge's question, and then may I answer yours?
Sure, I thought he got it answered.
The no damages for delay clause, the no damages for delay clause in this contract is no different from the no damages for delay clause that's in Carino-Civetta, Police Jericho, in all of those cases. The burden is on me to show that it was an uncontemplated delay. The TA agreed it was uncontemplated, so did we. I think the exception applies. With respect to superior knowledge, they expect you to believe that a year after Hurricane Sandy, they had not done an assessment, did not know how their resources would have to be allocated for the assessment, did not know approximately what it would cost to deal with all the damage, despite the fact that they were reporting to their own CPOC, as it's known, all of those things. And they're all in the record. The last thing I want to leave you on procedurally is this. This process whereby an employee of an agency determines disputes against that agency was challenged in the Westinghouse case, and it failed in that case because the Court of Appeals said, courts will conduct a thorough review of an arbitrator's determination when the individual is employed by a party and not simply defer to the arbitrator. I'd ask the court to contrast that with what Justice Rakauer said in this case at the record at page 19. She said she cannot invade the province of the CDRB. That is not the standard. It wasn't applied correctly below. And had she chose to do so, she would see that the parties agreed it was uncontemplated. This court has already found Hurricane Sandy was uncontemplated, and they had superior knowledge. Thank you.
Thank you. Thank you both. Mercedes versus 680.
May it please the Court, Mary Azaretto for the appellant 680 SN LLC. At plaintiff's deposition, she testified several times in several different ways that she was caused to slip as opposed to caused to trip in the area. When asked what it was that caused her to slip, she stated it was either rainwater or melting snow. The case law is clear that mere slipperiness on a walking surface
But
due
counsel,
to rain...
is that a fair characterization of the testimony? Didn't she say that there was a hole in the sidewalk 2 feet long by 2 inches wide, and there was water in that crevice, which was dirty and smelly?
What she said was that she slipped. She was asked directly, did you slip or did you trip? And she said she slipped. Yes, she was then asked later on in the deposition whether or not there were any holes in the area, but nowhere in the record is there any testimony by the plaintiff that the existence of a hole caused her to fall.
You didn't say that she fell in a puddle of water?
She said that
was in a hole?
she said that she slipped on water. In fact, she said it wasn't a puddle. She said it was some water. She was specifically asked if it was a puddle at page 187 of the record. And she said, no, there was some water. I was caused to slip, not trip. So the existence...
Yes, she slipped on water that accumulated in a 2-foot-long, 2-inch-deep hole in the sidewalk.
She did not say that if she slipped, the fact that the water was located in a hole in and of itself doesn't make the hole the cause of the fall. She never said that my foot went into the hole causing me to trip. She slipped. Whether there was a hole there or not, she slipped. She did not trip.
Isn't that really something for the jury to decide? That sounds more like weighing evidence to make that determination.
Only if there was some testimony in the record where she said that the hole caused her fall. And I respect...
Isn't that a fair inference from what my colleague just quoted, that she fell in a hole that was full of dirty, smelly water, 2 feet long by 2 inches wide?
I'm sorry. Not when she was asked directly if she tripped, and she said no. The fair implication is that if the hole caused her to fall, you don't slip on a hole. You trip in a hole. She was specifically asked, did you trip, and she denied it. The fact that there may have been a hole located nearby doesn't change that.
Page 193, I don't have it in front of me. Page 193, she didn't say that she tripped. I think my colleague already asked this. At page 193.
Page 193.
Because you're saying she denied it. I'm just saying at page 193, did she not say that she tripped?
No, she says that she slipped. She was specifically asked if she tripped or she slipped.
I know she said she slipped, but I'm saying, didn't she also say at page 193 that she tripped?
I don't believe so, no. I can turn to the page if you'd like. I know that she was asked if there was an existence of a hole, but she never says she tripped in the hole. She was asked by counsel at the completion of the deposition whether or not there was a hole in the area. That was the first time a hole was even mentioned. She was asked several times, several different ways prior to that point, did you slip or did you trip? And
All right, so let's just assume that there is a hole, there's this accumulation of dirty water. What evidence did you present regarding lack of constructive notice?
Well, the fact that she is claiming that the water came from rainfall, and there's well-settled case law which holds that that's not actionable, doesn't even get us to a notice analysis. In order to get to a notice analysis, you have to have a dangerous condition, and the law is clear.
So you're suggesting that a 2-foot wide crack, 2-foot long, 2-inch wide crack with dirty, smelly water couldn't be considered a dangerous condition under our case law?
I'm suggesting that she never said that the crack was what caused her to fall. And you have to have that finding.
But the water was in the crack, so isn't it a fair inference that it was the crack, the water in the crack, that caused the fall?
Only if it was physically possible to slip on a hole, and it's just not. If there was testimony in the record that said, yes, I fell because my foot went into a hole, causing me to trip or lose my balance, I would agree with you 100%. But when asked directly several different times, what is it that caused you to fall? And she said, I simply slipped. I slipped on some water. There is nothing in the record to indicate that she tripped on a hole.
Thank you, counsel. Thank you.
Thank you.
We have your point. People versus Ronaldo Morales.
Good afternoon, Your Honors. Whitney Elliott of the Legal Aid Society for the appellant, Reynaldo Morales. In this case, not one but 6 different factors contribute to the conclusion that the record does not affirmatively demonstrate that Mr. Morales understood and intelligently waived his constitutional trial rights when pleading guilty. First, there was no mention at all of his privilege against self-incrimination. Second, the court's, quote, "you will always have the right to a trial" language left it to conjecture whether he understood he would lose that right by pleading guilty. Third, he pleaded guilty to a felony and received a 6-month jail sentence. Fourth, he pleaded guilty to the entire indictment and did not enter into a negotiated plea with the prosecution. Fifth, this case was not actively litigated like 2 of the companion cases in Consecal. And sixth, there was no record that he had any conversation with defense counsel about the constitutional consequences.
Now, didn't the defendant also state that he had fully discussed the case with his attorney and that he fully understood fully understood that he was waiving, quote, constitutional rights?
So I guess I'd take that question in two parts, Your Honor. And he said, the question that the court asked him, have you fully discussed your case with your attorney? And the answer was yes. But that's not the relevant inquiry in terms of whether there was an intelligent and understanding waiver of the Boykin rights. As Consical and Terrell both confirmed, it has to be a confirmation on the record that not just had a general discussion about the case with defense counsel, but that it had a conversation with counsel about the constitutional trial rights that the plea would affect a waiver of. And Consical and Terrell, and also the third department cases we cited page 9 in our brief, address that.
You mean Herbert?
I'm sorry.
The Herbert case?
I think that's one of the third department.
Isn't it a little different, though? Aren't the facts there a little different? Because there was sort of a vague inquiry there as to whether the defendant had spoken to his lawyer. I think that's where the questions were. And there was no effort to explain the consequences of a guilty plea at all. Whereas here, he was asked, and he said that he fully discussed the case. And as my colleague alluded to, he also talked about understanding his constitutional rights. So the court, there's a much greater inquiry here than in Herbert, isn't there?
Well, I disagree, Your Honor. I mean, there are, in the third department cases that we cite, there are a few different variations, but I think they're all applying the same principle, that general inquiries about discussions about the case or this whole thing with counsel.
But I don't even understand that. I'm just looking at the colloquy. The court says, when you admit your guilt to this count to cover the indictment, you're giving up your constitutional rights, right to a jury trial, a bench trial, where your lawyer can call witnesses, cross-examine, et cetera, et cetera. It sounds rather more detailed than what you're suggesting.
So I guess a couple things about that. What those third department cases, the relevant inquiry is not whether there was an inquiry about this question about whether he had discussed the case with counsel or other aspects, but specifically whether they discussed the constitutional trial rights that the plea would affect a waiver of. And that's not what there was here. There was just, have you discussed the case with counsel? Now, in terms of the actual, Justice Singh, your question, the court didn't say, do you understand you're waiving your right, giving up your right to a jury trial? The court's colloquy was, you will always have the right to a jury trial. In such a proceeding, your defense counsel can do a few different specific things, and the question was...
But it starts, and when you admit your guilt to this count to cover the indictment, you're giving up your constitutional rights, and then it goes on to say what those rights are. So I'm not sure I agree with you.
No, it does not, Your Honor. It says, the very next sentence was, you will always have the right to a jury trial or a bench trial.
Right, if you don't give up, if you go to trial.
I think there's a dispute about whether whether it objectively means that or whether Mr. Morales understood it that way. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors, and may it please the court, Emily Galt for the people. As an initial matter,
I'm sorry, counsel. So it's clear that the court said nothing about self-incrimination. Is that in itself sufficient to find that the waiver was not valid?
This court has never held that the judge is required to list every single right that the defendant is giving up.
No, you're right. Not every single right, only the most significant ones. The right against self-incrimination is an important one, wouldn't you say?
Right, I agree, Your Honors. And defendant signed an appeal waiver, and although this is not barring his appeal because he's challenging the voluntariness, the appeal waiver specified the rights automatically forfeited upon guilty plea, and it specifically said the right to remain silent, the right to confront one's accusers, and the right to a jury trial. So the judge said the right to trial and the right to confront your accusers on the record, and the appeal waiver also had the right to remain silent. So given that, the fact that the defendant signed the appeal waiver, he confirmed on the record that he spoke with his attorney assigned the appeal waiver, all of those circumstances show that defendant entered his plea knowing intelligent.
What about what counsel is saying, that in expressing this, the court said you'll always have the right to go to trial?
Yeah, what the judge said wasn't confusing. He said when you admit your guilt to this count to
I think it was a she. I think it was Judge Whitman.
I'm sorry. What she said was not confusing. She said you're giving up your constitutional rights. You will always have the right to a jury trial. And then she went on. At such proceeding, your lawyer can call witnesses, present any defenses. And then she said...
Is that combined with her not saying anything about your right to incrimination? Um, Is that not confusing?
No, I don't believe it's confusing. And again, the judge didn't need to go through every single constitutional right. Again, there's no particular or mandatory catechism that the judge has to go through. So given all of this, his plea was valid. And if there are no further questions, we ask that you affirm. Thank you.
So I think just one quick point in rebuttal, or maybe that again, we're not trying to make the point that the single failure of mention one of the Boykin rights by itself requires invalidating the plea. We're asking the court to apply the totality of the circumstances and all the factors that I mentioned. Just in terms of the remedy, Your Honor, I would say this is the underlying conduct here involves him, my client, stealing shirts, socks, and underwear from a Macy's. He had no other felony convictions. So we think that not only should the court reach this claim in the interest of justice, but the court should grant either the remedy of a dismissal or reduction of the charge.
Yeah, you don't want to reverse and a remand.
Correct. That was, and again, if the court declines to do grant either of those remedies, we have, in the alternative, have just, rather than remanding for proceedings, that the court just affirm the conviction.
Thank you. Thank you both. NYCTL against Bethlight. Oh, yes, thank you. Justice Mendez is recused from the case.
Good afternoon, Your Honors. Michael Confusio for the appellant. I'd like to start off with saying that I don't think that this court's decision from March 2021 handcuffed Justice Kahn in terms of his evaluation of the motion to vacate that was filed below. You know, for one thing, if you look at the motion that was submitted below, both the affidavit of the attorney, Mr. Suture, which is in the record at 10, and then the affidavit of Pastor Manning, the head of the church, they detailed essentially what had happened at the Supreme Court level before Justice Bluth, I think it was. So if you look at this court's decision from 2021, it basically said, well, if there was an error in failing to hold a hearing before the referee, you know, that the defendant had an opportunity to raise questions and submit evidence that could be considered by the Supreme Court in determining whether to confirm the report. But what showed on the motion below, if the Justice Kahn, when he looked at those affidavits, is that that opportunity really was never there because the church essentially was completely deprived of its right to counsel, even at the Supreme Court level, even putting aside the referee issue. There was no argument made about the interest rate and when the interest ran. And the other thing I guess I would point out respectfully, I'm trying to be as short as possible, as I know the court wants me to be short.
No, if you can get to your points, we'll allow you to get to your points. I just don't want you to be repetitive or go over. So, but let me ask you this.
Sure, Judge.
You are saying that I'm sorry, it sounds like you're saying that it's because the attorney was subpar or just didn't do the job that he should have, that your client didn't really have an opportunity to put his issues forward, and that 50-15 shouldn't apply.
Yes, I mean, there's really two things. The first was the referee issue. There was really no opportunity to advocate there. But then even before the Supreme Court, the only issues that were raised by counsel for the church below was about the attorney's fees. I guess I would make this point. Even if the court looks at its own decision from March of 2021, which obviously I respect, but you know, even the cases that the court cites when it talks about, well, you had an opportunity to make these arguments, and they said the defendant didn't argue about the interest rate. The problem, I think, is this, respectfully. You know, the cases that the court cites are mortgage foreclosure cases. And this case is not a mortgage foreclosure case. I know it's a foreclosure case because of the tax sale. But the big difference is as follows. Mortgage foreclosure cases, when the court looks at them, it's typically like, okay, there's a principal that's owed and a small amount of interest that's tacked onto it. This case is actually the complete opposite. It was basically it's been a 20-year litigation back and forth over the exemption. And at one point, as we pointed out, this court actually ruled that the church was exempt, and that was actually the law of the case for 3 years. But here's the main issue. Never.
But then nothing was done, right? Nothing was done. The court ruled that, and then nothing got done. Didn't it sit? Go ahead.
Well, I'm just saying, right. I mean, at one point, if Your Honor remembers, I think it was in 2007, this court actually affirmed another Supreme Court decision in an Article 78 case and said the church is clearly exempt under the water exemption statute and didn't owe this debt. But here's my point. Maybe the plaintiff's right. Maybe it's an 18% interest compounded, and maybe the interest ran for the whole time, for the last 20 years without interruption. Maybe they're right. But in this kind of a case where you have such a small principal, $36,000, and essentially $3 million of interest, it involves a church, and it involves what even Justice Kahn said is equitable power to do substantial justice in the case. Isn't this the kind of a case where we should just have a small remand and have a square merits ruling on those two critical issues? And I think that's really what it comes down to in this particular case.
Thank you.
Thank you for hearing me.
Good afternoon, Your Honors. Tara Ward of Phillips Lytle on behalf of plaintiffs, respondents, NYCTL Trust, and the Bank of New York Mellon. Your Honors, there's not much I can say that this court hasn't already said about these tax liens and in this case. All of the issues raised on this appeal were previously raised before this court. They were addressed by this court, and they were rejected by this court. Defendant is now foreclosed from relitigating these issues under the law of the case doctrine. And defendant notably does not claim that there's been subsequent evidence or a change of law that would allow this court to address the issues. I won't waste the court's time addressing the propriety of having a hearing before the referee, because as this court already found, defendant had the opportunity to raise its computation issues, including the interest rate issue, to Supreme Court, and it failed to do so. I will just say, though, to respond to some of defense counsel's arguments, even if a computation hearing is warranted and to address the interest rate issue, it would be futile. Defendant admits in the affidavits cited in the record, if we had the hearing, what we would do, the substance of what we would raise at this hearing before the court would be, quote, essentially what we raised on the motion for summary judgment. The Supreme Court already passed on that issue. It rejected that issue, and it rejected all of those arguments, and those arguments included an interest rate argument. Failing that, the administrative code here, 11336, requires that any alleged defect on a tax lien certificate must be specifically pleaded, and that was not done here. There was no affirmative defense raised in either of defendant's answers that there's a defect with respect to the interest on the face of the tax lien certificate. Failing that, the referee here did not have the authority to address the legality of the interest rate. The referee was solely here to look at the interest rate on the face of the tax lien certificate, apply that to the amount owed on the tax lien, and then to compute what is actually owed to plaintiffs and plaintiffs here. Finally, the interest rate itself, it's presumptively valid. It appears on the face of the tax lien certificate. The law department and the Department of Finance both reviewed and approved the certificate before it was issued. And the interest rate itself is derived from resolutions that the City Council passed pursuant to the administrative code, which allows it to make these resolutions and set the interest rate here. The interest rate is 18%. At no time has defendant ever challenged the arguments the plaintiff has raised, especially on the last appeal, which is that you do have a tax liability. You're simply exempt from it. They have not addressed the exemption argument. They haven't addressed the resolutions that the City Council passed back in 2002 that apply here. Thank you very much.
Thank you.
The plaintiff's entire argument, if you look at the plaintiff's brief, with all due respect, the entire argument is waiver and estoppel. Because the plaintiff acknowledges there's never been a merits ruling, even if we put aside the rate issue, What's new in the affidavit below, and I pointed this out, but it's in paragraphs 137 to 139 of the Suture affidavit, is this issue raised about when did the interest run? Nothing defines when the interest runs in the actual tax sale certificate, and the plaintiff's position is the interest ran uninterrupted from 2002 on. Even if you took out the interest for 3 years, which was the law of the case for that period of time, in other words, when the court had ruled that the church was exempt, that makes a huge difference when you compound 18% interest. I mean, essentially what the plaintiff is at, the plaintiff is essentially held a lottery ticket, is really what it is. It's a $36,000 debt, and we're submitting that in a court of equity, in a foreclosure action, a small remand to do a merits determination of those two critical issues, interest and when did it run. That's all we ask the court to do. Thank you for hearing the case.
Thank you. Thank you both. Morgan Stanley versus Ciccarelli. What is it?
Ciccarelli, like
Ciccarelli. We just have to wait for Justice Mendez to get back to his seat.
Your Honors, in light of the non-appearance by my the other side, I'm happy to rest. Appellants are happy to rest on their briefs. And unless there's questions from the court, I believe this is, in brief, since I have 3 minutes, that this is a real party and interest case. The plaintiff bank divested themselves of ownership a very, very long time ago, before this action was ever commenced, in favor of a mystery third-party investor.
Counsel, was there standing shown by the complaint? Wasn't the note attached?
Yeah, there's...
Isn't that sort of the end of the inquiry at that point?
No, that's a presumption, Your Honor, and it's a rebuttable presumption. And in this case, it was very powerfully rebutted because plaintiff's own cooperating witness came forward on behalf of the Ciccarellis to testify on the Ciccarellis' behalf, to say that that's a factual statement in the pleading was not true, that it's bested by evidence under CPLR A7, right? And you can raise standing at any point in time, and of course there's the recent enactment of RPAPL 1302A, that standing is never waived. So it was rebutted. It couldn't have been rebutted in a stronger way. Declaration, we had a cooperating witness from plaintiff. And I think this case highlights what former Chief Judge Kay said about the problem with the mirror system, right? It's a private market and secrecy. There is no transparency. They wasted the lower court's time under all these 34OF conferences. They have a duty under 3408F to give accurate information to the court, and they didn't. That was bad faith. And on top of that is the common law duty implied in every contract, and a note, and a mortgage is a contract, of good faith and fair dealing. There was no good faith. It was the opposite of good faith and fair dealing. It was bad faith. And so when we were at these conferences, it was Johnny one-note negotiation. Oh, here's and we qualified. We qualified, the Ciccarellis qualified for a restructuring of the mortgage. By who? By Plaintiff Bank. Then, 5 months before this action was ever commenced, they pulled the rug out from underneath us and they mysteriously sold it to an undisclosed third-party investor, which Mr. Pellegrino says is entirely consistent with the New York Times investigative report, Goldstein, about how the surreptitious market works and hurts homeowners in secrecy. So that's the essence of the case. Justice is on our side, and the Federal Truth in Lending Act is not supposed to be a dead letter. There's damages. You don't comply with the Federal
Thank you,
Truth in Lending
counsel.
Act
If you
in
would,
30 days.
thank you. If you
Thank you,
just
Your Honor.
wrap up that.
Sorry for going over.
It's okay, I understand. Georgia Malone versus E&M Associates. Justice Singh is recused in this case.
Good afternoon.
Good afternoon.
May it please the court, Douglas Hirsch, Sadis and Goldberg LLP, for all of the defendant appellant respondents except for Michael Langer. I'd like to start by asking your honors to turn to page 226 of the record, which is an agreement entitled the Singer-Malone Unwind Commission Agreement dated May 9, 2013. That is an agreement between Georgia Malone, Malone and Company, and the seller of the properties, Baruch Singer. And in that agreement, the pertinent paragraph is, quote, "The undersigned broker hereby represents that it is the sole broker bringing about the transaction."
Hey, counsel, I'm sorry to stop you. You represent the defendant. Did you just say
Defendant
that?
appellant responded, yes. Manhattanville Holdings.
You have a cross appeal, don't you?
We filed the first appellate brief here, and it was our appeal, and they have cross appealed.
Huh?
Okay.
Oh, okay.
All right, continue then.
I'm sorry. So.
No, I interrupted you.
We are on page 226 of the record, the Unwind Commission Agreement, and I'll just state again that that's an agreement between Georgia Malone and the seller of the properties, Baruch Singer, and it says, quote.
Look, the bottom line is, I understand the record. Let's cut right to the chase. It's either there's an unwind and there's a sale. Your argument is Georgia Malone took the position in another action, the Galanta action, that they were together. There was one transaction because the attorney was litigating in the Galanta action looking for his fees, and the argument that Georgia Malone took at that time was the transaction was essentially one, not two, right?
Correct.
In this case here, the argument's the other way. That it's two transactions. It's a unwind and a sale. So now, in this case, Georgia Malone is seeking from your clients the commission as a result of the sale, right?
Correct.
And so you're saying, wait a minute, you can't have two inconsistent positions, and that's where we're at. So
Correct.
You're saying that you should win, and this case should be gone.
Correct.
That's it.
And
That's the
Okay,
bottom
so
line.
I have a question, maybe you won't say correct to, but in any case, let's just sort of play this out. If Mr. Singer, who was the seller, felt that Georgia Malone had done everything with the unwind, even though the unwind didn't conclude this, even though it ended up, that didn't happen, and it was a sale in the end. Is there any view of this that, because if Singer felt, you know what, they did everything that was necessary, I'm paying them anyway, that's why I paid them. Is there any view of that
Singer would have not paid her. Mr. Castro, Ms. Malone, Singer, they all said that the closing, and to quote Claude Castro in front of Justice Singh in the Galanter action, the closing was, quote, the kingpin. Malone testified the sale was part and parcel of the unwind. It was all critical to the unwind. So there's no way Singer would have paid them, paid Malone. And where the lower court made a mistake, the lower court correctly found that Malone is stopped from arguing they're two separate transactions. Once the lower court found that, The lower court erred by saying there was an issue of material fact as to whether she was Singer's broker. And I'm pointing to the unwind commission agreement signed by Georgia Malone where she represents that she is Singer's broker. There can be no material issue of fact. She states in writing, I am Singer's broker on the unwind. The unwind and the sale are one transaction. I got paid $2.45 million for it, and now I want to double dip and get another $3.5 million from my clients.
I know
without
she says everything that you just said, but I'm asking you is, was Singer deposed here?
Yes.
And did he? Okay.
He testified that he doesn't understand why Georgia Malone is now suing for another commission. He paid her a commission for $2.45 million, and it was his understanding that that included the sale. That's his testimony.
Okay, so that it was no version of that where he could have just said, this was just for the unwind, even though there wasn't.
No.
The unwind didn't conclude this. Okay.
No, but the critical point here, as a matter of law, just as Georgia Malone cannot submit an affidavit contradicting her admissions in the case to create a material issue of fact, she's already admitted it was one transaction. She testified under oath. She can't create a material issue of fact in the case by contradicting her own testimony by pointing to a non-party, Singer's testimony, no matter what it says. That does not create an issue of fact. This is a 2014 case. We've been litigating this for 8 years now. She deceived us. She duped this court on the prior appeal by not telling us anyone about her testimony in the Galanter action. And it's got to end. This should never go to a jury at this point. She conceded liability. And once she conceded liability, she doesn't get to say, there's an issue of fact, look at this document, look at someone else's testimony. Thank you.
You're coming back, aren't you? Maybe you ought to leave it in the corner there somewhere.
Your Honors, Travis Tatko for Michael Langer only. We are aligned with Mr. Hirsch's positions on all of these issues, but I want to bring up just one quick overarching theme here, and that is beyond the fact that these transactions, the unwind and the sale of the properties were one and the same as acknowledged by Georgia Malone repeatedly in the prior proceeding, and beyond the fact that there is a dual agency here of a real estate broker and a real estate agency, meaning Georgia Malone and her company, George Malone & Co. There's something more basic and fundamental, which is that Georgia Malone did not share any of this information, notify my client or any of the other affiliated defendants in this action regarding all of these interrelated transactions and affiliations with Baruch Singer or anything else. And not to belabor the record, because it's firmly established that beyond doing one site visit or just a basic site visit to some of the properties, there was no negotiation on Georgia Malone's part in terms of purchase price or anything that a traditional real estate broker agent would do for a client. And as a licensed real estate broker and also an attorney, Georgia Malone should know better, and her firm's attempt to double dip here is pretty outrageous. And for those reasons and the reasons of Mr. Hirsch, we ask for a determination in our favor, Your Honors. Thank you.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
May it please the court, Claude Castro for the cross appellant, Georgia Malone.
So, counsel, at the very least here, doesn't contemplated transactions raise an issue of ambiguity that should be dealt with at trial?
No, Your Honor. If I may just go through some of the documents. The first document, obviously, is what counsel just referred to, which is the brokerage agreement between Singer and Ms. Malone. Now, what they're trying to do, and it's very important, there is a term, transaction, capital T. It is a defined term in this brokerage agreement. What was discussed in the Galanta case had nothing to do with this definition. They were using the word transaction in a generic term, and I'll get to that. But if you look at the brokerage agreement between Singer and Malone, it very specifically says that she was going to earn a commission with regard to the negotiation of a certain unwind letter agreement and the contemplation of the transaction contemplated thereunder. Now, we have to go to the unwind letter agreement that Ms. Malone negotiated on behalf of Mr. Singer. That agreement says it was to negotiate a restructuring of Mr. Singer's debt, bringing in an investor who's going to bring in $55 million of new equity, and if and only if Mr. Singer refinanced this property, brought in $55 million of equity, at that point, then AMCO would terminate an option, which was the whole purpose of this document. The option gave AMCO the right to purchase the property at a very low price, which Singer had to get rid of.
Right. It was to terminate the POP agreement and the payoff of AMCO.
But it was to pay it off, Your Honor, by way of refinance.
By refinancing, which did not happen. Instead, there was the sale.
Except, Your Honor, what she was hired to do and what she negotiated was not a sale. It was a restructuring. The fact that Mr. Singer violated this agreement, because if you look at the terms of the, not only the May 9th letter agreement, but the forbearance agreement, which incorporated all the terms, it said specifically if Mr. Singer did not refinance and apply for refinancing within 30 days, and if he didn't get new equity within 30 days, he was in default, and AMCO could then foreclose on him, and he waived all defenses. Again, there was never any contemplation of a sale. More importantly, Your Honor, Singer, they tell you, comes in and said, I paid her for the sale. Well, they ignore the fact that the contract of sale that Singer signed to sell these properties, he specifically represented and warranted that he had no broker on the sale. And this, I submit to Your Honor, if she was not Singer's broker on the sale, as he claims and represents in the contract, then all of the other counterclaims fall, Your Honor. Because if she was not Singer's broker, there's no dual agency. And if she was not Singer's broker, she couldn't have committed fraud in the inducement.
Well, she seems to say that she was and she wasn't, right?
No, Your Honor.
Once it's one, and then another time it's two different
No,
transactions.
Your Honor. She was hired only with the unwind. Let's get to the Galanta, which they've confused the record completely. Let me try and correct it. Judge Singh, and I wish he were here, the reason the issue about one or two transactions was not raised by Malone in the Galanta action. If you look at page 25 of their main brief, it was raised by Galanta himself. Why? Because we had raised an issue that as an attorney, he could not be both an attorney and a broker on the same transaction. To get around that, Galanta, Singer's lawyer, he's the one that created the one or two transactions. To avoid his ethical obligations, he said, no, 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 I was a broker on the unwind, and then I became a lawyer on the sale. And we have, Your Honor, in the record, an expert's opinion, Mr. Minkoff, one of the most renowned experts on ethics in the state. He very clearly stated that an attorney, Ethics 101, if you're an attorney on a transaction, real estate, you cannot be the broker. Disciplinary Rule 1.7. But he had another problem, Your Honor, and the problem is he was associated with another firm, Goldberg Weprin. And because Goldberg Weprin was the attorney for Singer on the unwind and also on the sale, Mr. Minkoff made it very clear that Mr. Galanta's argument that the unwind was one transaction, the sale was another, as to him, ethically, it was one transaction. Why? Because as Mr. Minkoff says, Disciplinary Rule 1.10 says, an attorney who's affiliated with a firm cannot be a broker. and no attorney, he says in his report, none of the attorneys at Goldberg Weapon could act as a broker on either the unwind or on the sale. That is why we raised that issue. We weren't talking about the definition of transaction as in this May 9th brokerage agreement. That was never before the court. And on top of it all, Your Honors, the only reason this came up is on the issue of ethics in the Galanta case. And may I refer you, if I may, because my colleague who did the brief didn't refer to this, but if you go to the transcript, Judge Singh specifically said, when I was asking him during a charging colloquy, we want to have the jury determine whether or not Galanta violated his ethical obligations, whether it was one or two transactions as to him. And what Judge Singh held at that trial, he said, no, I will not give the ethical issue to the jury.
I understand you're talking a lot about Galanta, but it seems like Georgia Malone and company made statements as well that suggested that she was in one capacity, or at least the transaction was one thing on one occasion and was two separate things, an unwind and the sale on another occasion. It seems to me that and a number of other things raise issues of fact with regard to the ambiguity of this contemplated transaction.
Your Honor, with all due respect—
I'll give you 30 seconds if you want to respond
30 seconds, please. This is where they confuse the record. When Ms. Malone and I said in the Galanta action that it was one transaction as to Galanta, it was based on the ethical defense that we raised. It was he could not break it up into two transactions to get around his ethics obligations. That's what we said. It is not inconsistent with the position we took in this case, and we come back to the issue, Your Honor. Okay. She could not be a dual agent if Mr. Singh stated in his contract that she was not his broker.
Thank you. I think the 30 seconds are up. Thank you very much.
Your Honor, what Mr. Castro just said to you about the ethical defense is completely incorrect. If you look at the trial transcript in Galanta, the ethical defense never went to the jury. Judge Singh dismissed it, said it was irrelevant. The Minkoff affidavit never went to the jury. Minkoff never testified. After Judge Singh dismissed the ethical defense and said it was irrelevant, the jury, while they were deliberating, came back with a question, and the question was, is the unwind and sale one transaction? That was the jury question. And Judge Singh asked Mr. Castro, is it your position, is it still your position, now that the ethical defense has been dismissed, that the sale and the unwind are one transaction? And the lower court cites the whole colloquy between Mr. Castro and Judge Singh in the decision where he says, yes, it's all one transaction. The sale is the kingpin. He just told you something that is completely the opposite of what he told Judge Singh. It's in the record. One last point. There's a procedural issue. They claim that you're allowed to search the record, and they've now for the first time introduced all these new issues asking for summary judgment on all these things that were never discussed in the lower court, were never brought before the lower court. There's a case by the Court of Appeals that was not cited in our brief that I'd like to hand to you that I notified Mr. Castro about yesterday. The case is James Dunham versus Hilco Construction Company, 89 NY 2nd 425. And I'd like to hand that up to you.
It's okay. You gave us the citation.
The case says that the appellate court cannot search the record where the underlying claims that they're now trying to have you search the record on were never discussed in the lower decision. The claims have to be at least at issue in the lower decision before the claims can be reviewed by you on a search
Thank you.
record.
I think we will.
And the only thing that was ever done in the lower court is we moved for summary judgment on our counterclaims, and they moved for summary judgment to dismiss our counterclaims. They never discuss counts 1 and 6. It was never before the lower court. Thank you.
Thank you.
Your Honor, Your Honors, I once again have to correct counsel. Look at the record at 902 to 903. Judge Singh did not dismiss our defense that he was ethically, I'm talking about Galanta, barred. He states very clearly, he says, he was talking to me, as I told you, I will preserve that issue. I'm giving, get copies of my, there is a question with respect to whether he was acting as a lawyer. That issue is preserved as far as I'm concerned. That's a legal issue for me to decide post-trial. And then he goes on to say, the second issue that I was mentioning to you, that if he was of counsel to the firm, then as far as he was concerned ethically, it was one transaction. At page 903, Judge Singh says, sure, I don't have a problem on post-trial motions if for some reason, if it's found there wasn't an agreement that he was a lawyer. You want not just attorney, but of counsel for this law firm. So he preserved it. He said, if Galanta wins and gets a judgment, which he lost, then I will consider. He never dismissed it. So again, our reference to one transaction, which they keep harping on, has nothing to do with the definition of transactions in the brokerage agreement or in the forbearance agreement or in any other of the documents before the court. Lastly.
Thank you. We've got it. Thank you very much.
Thank you, Your Honors.
People versus Ernest Bristol.
Good afternoon, Your Honors. Katrina G. Myers for the Office of the Appellate Defender for Ernest Bristol. The court should vacate Mr. Bristol's convictions for promoting prison contraband and possession of a weapon because the alleged shank was never recovered and because the other evidence failed to demonstrate that Mr. Bristol was in possession of a weapon. To reach a contrary decision, this court would have to reach the outrageous conclusion that Mr. Bristol, an allegedly irate armed menace, was put back in dock custody while possessing a weapon. It is unthinkable that trained court officers and a trained dock officer would abandon their training and duties and jeopardize the safety of other officers as well as the prison community and the court community by putting Mr. Bristol back in general population at Rikers.
This did go to the jury, right? This
Yes.
instance did go to the jury. They had a chance to examine the credibility of the officers and...
Yes, Your Honor, and this court is able to sit as the 13th juror and reach its own determination about the weight of the evidence and should do so here.
Understand that.
The testimony of both witnesses should not be credited, firstly because of the
counsel,
abandonment.
I'm sorry to interrupt you, but even before that, didn't the defendant threaten to cut his attorney and the judge?
Your Honor, Mr.
And then, hold on, and then afterwards, it was shortly after that where the court officers observed, or allegedly observed, I guess from your position, defendant with this weapon. So isn't there circumstantial evidence or suggesting that would give the jury a basis to reach their determination?
The jury, the officers did testify that Mr. Bristol made a threat while he was up in the court area after the appearance, and then again when he was down in the holding cell. The jury should not have reached the conclusion that the officers correctly thought that Mr. Bristol was possessing a weapon, given the fact that the pen area was searched. He brandished the weapon while he was locked in a holding cell. He was with 5 other inmates. It's unreasonable to conclude that the guards would leave Mr. Bristol with the weapon locked in a holding cell. The officers did respond to the area and he was searched. They went through all of his clothing, his shoes, pants, socks, and shoes. They searched the cell, they searched the other inmates. They strip searched Mr. Bristol, had him bend over and looked at the area around his anal cavity, and a weapon wasn't there. It's unreasonable for the jury to conclude that Mr. Bristol did indeed.
Well, does that mean that a weapon wasn't there or a weapon wasn't observed based on based on the circumstances?
Could you repeat that, Your Honor? I'm sorry.
Was it that the weapon wasn't there, or a weapon just wasn't observed when they had him squat and observed to see what they could find?
Your Honor, I'm not sure if the weapon was not observed. Perhaps the officers mistook something else Mr. Bristol was holding for something else. The record does show that he was making some outlandish comments while he was being brought back into custody, or the officers could have simply misremembered the facts. The testimony does not show, their combined testimony does not give an exact description of the weapon. One officer says the blade was half an inch long. The other says it was 1 to 2 inches long.
Wasn't there testimony also that he was not in the pen, but that he was just outside of the pen when he brandished this?
Their testimony conflicted on that point as well, Your Honor.
But then wasn't the jury able to determine that he was outside, and in all of the confusion, they put him in and then called backup right away?
The jury could reach that conclusion, but then again, Your Honor, the weapon was not recovered. There was no evidence that a shank existed. The DOCS officers went through every search protocol possible to find this weapon, and it was not recovered. There weren't any markings of a weapon anywhere in the cell, on the other prisoners,
Counsel,
on Mr. Bristol himself.
the people is not required to prove that the weapon was recovered, just that the defendant possessed it. You have testimony that 2 officers saw him in possession with the shank. Yes, he was searched, but he didn't. He wasn't subjected to the anal cavity search. You had the testimony from the expert to talk about how weapons are secreted.
That's correct, Your Honor. And Mr. Bristol's second position is if the court does not vacate his convictions, that you reverse and remand, because that expert testimony should never have been entered. It was baseless speculation about the most common ways inmates hide weapons. The prosecution's expert said that's by anally secreting them, and then gave examples of how a prisoner could achieve that feat.
Did you object to that testimony at trial?
Yes, Your Honor.
With respect to the boofing, I know generally you made an objection, but specifically with respect to what we're talking about now.
Yes, Your Honor. Defense counsel objected throughout Mr. Fayed's testimony, specifically when the prosecutor asked what is the most common way that inmates conceal weapons. Counsel objected and said that any testimony that the expert would give was irrelevant. And then the expert responded that the most common way is through boofing. And considering that it's expert testimony, the only way it could be irrelevant is if it's not factually grounded in the record. And here it isn't. The officer testified that Mr. Bristol—
I'm sorry, but that comment you made, you're saying it was specifically, it was during the testimony at boofing? I thought that was an objection to the expert generally, that we object to this expert testifying.
Your Honor, he objected generally, and then he did object specifically. If Your Honors refer to page 202 of the trial transcript, the defense counsel did pose an objection to the prosecution asking about the most common way in which inmates often hide weapons. And if there are no other questions, I'd like to reserve some time for rebuttal to answer your other questions. Thank you.
Yes, you have it.
Your Honors, and may it please the Court, Anna Nachik for the people. Defendants—
Counsel, even though the people don't have to prove that the weapon wasn't found, or don't they still, I mean, doesn't the fact that this weapon exists nowhere, that there was this extensive search, and of even the other inmates that were in the cell. Doesn't that suggest, I mean, isn't that strong evidence that the weapon didn't exist, that the police officers were wrong, or?
No, Your Honor, because both officers testified that the object was a shank, that they viewed defendant with it. The officers testified that the object was about 1 to 2 inches.
But they differ on the appearance of it, and then there's all this speculation about black electrical tape, where they don't mention that it's black. I think they mention that it's silver and white.
Officer Jusau testified that it was silver and white. Officer Escalona testified that it was partially wrapped in electrical tape. They also had different viewpoints of the shank, so that can be credited to, their differences there can be credited just to their different viewpoints. Also, this is the type of minor inconsistencies we would expect from two officers who are observing and reacting to this in real time, a very hectic and unusual situation. Additionally, the expert did offer possible reasons for why the shank was not recovered. He just never offered an opinion as to exactly what happened in this case. And any arguments as to whether or not the expert...
Well, what about counsel's argument that the expert shouldn't even be considered here because there was no basis factually for the expert's testimony about boofing, because no one was even able to suggest anything about that? I mean, that was just no weapon. After searching everybody, there was no weapon. There was no specific factual testimony of anything other than taking it away from his groin area.
Well, the argument that there was no factual foundation for the testimony is unpreserved. Defense counsel never objected on those grounds, and as this court acknowledged in People v. Tejada...
But what about counsel's statements just now that this was in the beginning, but it also was when throughout, there were objections throughout the testimony by the expert?
There may have been objections throughout, but there was never an objection on the ground that it lacked a factual foundation. And it didn't lack a factual foundation. Both officers testified that the defendant reached into his groin area to produce a shank, and Jusau testified that he reached back into his groin area to hide the shank again.
When you use the word back, we're not talking about his rectum, we're talking about his groin area in the front. Everything that the expert said had to do with his rectum and hiding something in electrical tape there.
Correct. The officers did testify that it was his groin area. There was no testimony as to whether that was the front or whether that was the back. It was just the general groin area. However, there was other...
You know what? I think that if they meant his rectum, given all of the expert testimony getting an expert to say that, I think if they meant the rectum, they would have said he put his hand behind him. I think that I've never heard anybody talk about the groin area as the area in the rear of a person's body.
Well, both officers just testified generally as to the groin area, but the expert witness in this case also offered other possible explanations for why the shank was not recovered. He explained that the defendant could have given it to a different inmate, that it could have been flushed down the toilet. But he never offered an opinion as to exactly what happened in this case. The people just argued in summation that it was likely hidden in defendant's anal cavity. There was never an objection to the summation, and that would also be unpreserved. Additionally, as to defendant's claims regarding his guilty plea being that they are also unpreserved and meritless, as defendant did knowingly, intelligently, and voluntarily plead guilty. The judge's discussion as to defendant's possible sentencing exposure after trial did not render the plea unduly coercive. And if there are no further questions, we ask that you affirm.
Thank you.
Thank you.
Thank you, Your Honors. If I could briefly touch on respondent's preservation argument, counsel did object to the relevancy of expert testimony. If, in my view of the law, the only way expert testimony would be irrelevant is if it lacked a factual foundation in the record.
So just picking up on that thread, it's a discretionary decision, agree, as to whether or not to permit expert testimony?
Correct, Your Honor, but...
Okay, let me finish. Just, could the testimony be a basis to explain why the shank wasn't found in this case?
No, Your Honor. Respondent did argue in her brief that expert testimony could be used for background information. However, background information must still be based on the facts in the
Okay,
record.
so in this case, the officers testified that they observed a shank, but the shank was never found. So isn't there a connection? And doesn't the expert testimony bridge that connection?
Your Honor, the courts require more to call an expert to testify about a missing piece of evidence. This court should look at the Court of Appeals case of People v. Brown, which is cited in the brief, and also the case of, I think I'm going to mispronounce it, I apologize, People v. Ignatiev, where the court decided that testimony about fragmentary blackouts was inadmissible, where the evidence to support the testimony there was no evidence to support the testimony other than the fact that the witness was forgetting things. This case is similar to that. The only evidence that Mr. Bristol allegedly anally secreted a weapon was the fact that a weapon wasn't recovered. He was searched. The officer had him bend over and looked inside his anal cavity, and the weapon wasn't there. There were no markings around Mr. Bristol's anal cavity of a weapon. The expert testified that Mr. Bristol would have been seriously injured if he put a shank in his rectum. This did not happen. They were required to call medical staff if it did, and they didn't do it. If there are no other questions, I ask that this court vacate Mr. Bristol's convictions and dismiss the indictment, and the alternative remand for a new trial based on the unfounded expert testimony. Thank you.
Thank you. Thank you both. Chris Grant, Brohawk Films versus Digital 7.
Judge, good afternoon.
Good afternoon.
Respondents didn't come. My name is Edward Hayes. I'm arguing on behalf of both Brendan Cochran and Digital 7, and frankly, I'm here is because the lower court described my discussion of my wife's illness as a hard luck story. That is not correct. My wife has suffered terribly for 10 years. I must say that there came a time when that suffering came to a head. It came to a head, and I folded. I couldn't take it anymore. And I told the judge that. It was in my papers and my affidavit. If the judge did not believe me, I think she should have brought me down there and asked for further proof first. Secondly, the meritorious defense is fully covered in the briefs, and I'm not going to raise any issue there, except I would like to thank the lawyer for the appellant, the respondent, for writing so compassionately about my wife. Thank you.
Thank you. Garage versus Tower Insurance.
Good afternoon, Your Honor. My name is Paul Golden. I'm representing Ms. Farage, in this case, the appellant. My client had insurance. My client had the exact kind of insurance that was necessary for this kind of matter. The insurance companies, the insurers, had their own way of setting up timing for this. It can become a catch-22 in certain situations, and the executive...
So there's a 2-year limitation period here. What allegations do you have in the complaint of what steps your client took within the relevant 2-year period that may give you a basis to argue that we shouldn't enforce the limitation period?
So there was a number of references in the underlying complaint about this one. Some of them were about all the difficulties that she had in trying to...
That's not what I'm asking about difficulties. Okay. I'm asking what steps were taken. Were repairs attempted within the 2-year period?
Yes, she was doing repairs.
What allegations in the complaint support that specifically?
Give me 1 minute.
My reading of it is that you essentially say that Tower refused to pay invoices, which essentially caused liens to be placed against the property, which resulted in your client's inability to get financing and, of course, then inability to repair within the period.
Well, there's certainly some of the issues in the complaint concern the delays caused by the insurance company. There were some allegations about that and how they took too long to take care of certain matters, and that was part of the reasons.
But the plaintiff could have, I mean, you had two choices, make the repairs or bring an action in court. There was no action in court in those 2 years either.
Well,
I mean, I'm saying that if they were dragging their feet and if there were so many problems with the insurance company not following through, and why not bring an action? Because you have that 2-year statute of limitations within the contract.
Well, I just want to, if I can answer Judge Singh's,
I thought you had
Singh's matter first. There was a discussion in paragraph 8, which is on page 121, about the massive structural damage and how it would take multi-years, and it was a multi-year process. There is some of that discussion within that. Throughout the complaint, there's various references to why the matter was taking so long.
Well, that's delay.
I'd like to.
I'm sorry, that's delay. You still haven't said what steps were taken.
Well, she was actually taking steps. She was repairing the process, repairing the building. It's just that the final, it had to be completely repaired according to their rules. Everything had to be done before you could file a lawsuit. And I'd like to address what Justice Renwick would just indicated. It would have been a frivolous lawsuit for my client to have filed an action and said, well, I'm not done with all the work yet. I'm sorry I'm not done with all the work yet, but let me file the action anyway. That would have been frivolous. That would have been improper for someone to file, because then all the insurance company would say is, well, it says on this other page right here, you can't even file a lawsuit until all the work is done. My client was doing work throughout. It's just that she couldn't do all the work, and that's partially because of the nature of the work, and it's also partially because of all the delays caused by the insurance companies. Now, the problem here is that Judge Angoran did not, instead of reviewing the Executive Plaza decision, well, he did review it, but he didn't apply the law properly. The law on that one indicates that it's the insurance company's burden to prove that my client had delayed or somehow not come through, or that was unreasonable. My client's position is it's unreasonable. They would have to prove that it was a reasonable policy, that it was a reasonable amount of time. That's what the Executive Plaza stands for, and that's what the Turner construction case that I cited stands for as well. It becomes the insurance company's obligation to prove that the 2-year limitation is reasonable under these particular circumstances. And my client's complaint goes into detail about what the structural damage was and how long it would take to get this done. I'll also mention to you at the very end of the day, when Judge Angoran finally decided the renewal and re-argument motion, it appeared that he may have been swayed by the arguments below, indicating that yes, maybe there is an issue of fact here about whether this was done, whether the time limitation was reasonable or not reasonable under these circumstances. But instead, Judge Angoran went on to a totally separate subject and said, well, the claim was submitted too late. I believe what Judge Angoran was talking about was the 180-day rule, which even my adversaries at this point say was not applicable. I'll reserve my right for rebuttal. Thank you, Your Honors.
May it please the court, Kevin Buckley on behalf of Tower Insurance Company and the other insurance companies.
So, counsel, I hear your adversary is saying that, in fact, steps were taken within the 2-year period to make repairs. Are there allegations of that kind in the complaint?
No, Your Honor. There is one conclusory statement on the record at page 112, paragraph 32, that the insured states she was unable to complete restoration until July 2020. And then within a month thereafter sued before the insurance company even responded. The I submit that the trial court properly applied Executive Plaza in this case. And what the trial court said is, unlike the insured in Executive Plaza, here the insured did nothing to protect her rights as the suit limitation expired.
How could she protect her rights? I mean, if you have two clauses in the contract that says, one, you have 2 years to commence an action, and two, you can't commence an action until all the repairs are completed, what could the policyholder do to protect her rights in that scenario?
What the policyholder could do is what the Court of Appeals told them they have to do in the Blitman construction case. In Blitman construction, the Court of Appeals said, an insured is bound by the terms of the contract, whether read or not read, and can protect itself by either beginning an action before the expiration of the limitation period or obtaining from the carrier a waiver or extension of its provision. And the Executive Plaza Court relied on Blitman.
Well, there's no way that she was going to get a waiver, because with all the communications, it seems like you would have given it if you had any intention to.
Excuse me, Your Honor? A waiver was never requested.
Yeah, I don't know that a waiver, anyway, go ahead.
But anyway,
Rhetorical.
what the Executive Plaza decision says, and it relies on Blitman, and Blitman says either start the suit or ask for an extension. If they had started the suit as they did in Executive Plaza and the insurance companies moved to dismiss as premature, then we're in a case where we have Executive Plaza and that provision is now unreasonable. That is what the court said in Executive Plaza. It said it is unreasonable for it to now say a day later it would have been too late. That's what made it unreasonable, not that it was 2 years or that the suit it took too long to make the repairs. It was unreasonable in that the insured complied in Executive Plaza with the 2-year suit limitation provision. She commenced the suit within the allotted amount of time, and then it was dismissed. So she was put in a catch-22 in Executive Plaza by the insurance company. And in that specific situation, it is unreasonable to enforce the 2-year suit.
The insurance company will lose in that scenario when there's a catch-22. That's what you're saying. That's what the case law stands for. So if she had commenced the action, it was dismissed, she would have been in a catch-22 of falling right into Executive Plaza.
Right, and I would just like to add, with regard to the repairs and restoration, there are a number of other breach of contract claims in this suit that she could have commenced within 2 years, such as on page 112, paragraph 34, Tower refused to pay for loss of rental income and other damages, including replacement of personal property. In the summons itself, record at 96, it says defendants are attempting to assert an underinsured penalty. There are a number of these types of alleged breaches of contract that did not require a completion of the repairs for her to commence suit. And with that, unless there are any questions, I'll ask the court to affirm. Thank you.
I would just like to address a few issues, Your Honors. The primary one is about Executive Plaza. There is no known case, none that's ever been cited by my adversary or anything, indicating that there is an obligation to first file a frivolous lawsuit, which is bound to be dismissed.
But why is it frivolous? Your adversary says that there are a number of claims, for example, that don't even relate to the issue of completion. So why would it be frivolous, especially under circumstances where Tower is not paying your invoices?
Well, the primary issue here, and the only issue that was really at display here, Your Honor, we have to remember that this is a 3211 motion. This is before there's any discovery, before there's any opportunity to explain anything, before there's anything. All it is them saying, waving around the 2-year limitation, say, that's it, we don't have to explain anything else, we don't have to produce an affidavit, we don't have to...
But what your client has was all the difficulty. I can't, it's not working out, I'm not able to finish, document what she is doing and the difficulty she's having with
my position,
repairs.
My position was there's two responses to that. One is it's in the complaint. There's detail in the complaint about why there was difficulty, why it would take multi-years, why it would take more than 2 years. That's one issue. The other issue is that it's the burden of the insurer. this state has this idea behind it that there's insurance companies and then there's people insured. And there's got to be the right protection to the insured. In this case, there's just a small thing, which is that they have the burden. If they're going to make a motion for 3211 before there's anything done in the case, then they've got to hit that very, very, very strong burden that there's not one aspect of this case which could proceed. There's no human way it could be done. And that was issued in the Turner construction case, and they simply didn't meet that burden. Thank you so much for your time.
Thank you. 865 First versus State of New York Division of Housing.
Good afternoon, Your Honors. May it please the Court. Jordan Hyman, representing the appellant 865 First, LLC. Why was the DHCR's decision clearly arbitrary and capricious in this matter? For several reasons. First, the DHCR knew about the pending housing court eviction proceeding based on...
Hold on 1 second.
Yes.
The housing court proceeding was against the parents, correct? For holdover.
Correct.
It didn't name the daughter. It couldn't name the daughter.
It could name who?
It could not name the daughter. That
no, it named the daughter. We knew.
The daughter. So it had all three, the parents and the daughter, in the holdover proceeding. And that was a non-primary proceeding, right?
Correct.
Non-primary in the sense that, my understanding of my recollection is that the tenant of record is seeking a renewal, and the landlord saying, I'm not giving you a renewal because this is not your primary residence.
Well, it's a little bit the opposite. This is a landlord-initiated proceeding, where the landlord is seeking to obtain possession from the tenant of record because the tenant of record is not residing in the premises. The undertenant...
As a primary resident.
Correct.
Right?
Correct.
Okay.
The undertenant has a right. What usually happens with these cases is either one, the primary tenant is going to argue that it is their primary residence, or two, the undertenant's going to come in with a succession claim and tell you why they should be able to live there.
So now let's move to the succession side of this. My understanding is, why is the primary issue, the primary residence issue, so important with respect to the succession right? Because I was reading the record here, and it was towards the end of the transcript where the argument was raised that primary residence of the tenant of record is not an issue with respect to succession rights.
That is my whole argument of why, part of why this whole thing was arbitrary and capricious, because...
Well, do you have a case that says that primary residence of the tenant of record in a succession issue is an issue that needs to be resolved?
Yes. Well, first, if you look at 25-23.5 of the Rent Stabilization Code, it specifically states that the parties have to live together for the 2 years.
Right, but that doesn't talk about primary residence of the tenant of record.
Well, it is, Your Honor, because they have to live together. They can't be living upstate, okay? And then the parents can't be living upstate.
You're absolutely right. But if they live upstate and they come down for like 30 days out of the year and they're cohabiting, the person seeking succession rights cohabiting in those 30 days with the tenant of record, you got the cohabitation there.
But the cases, especially the cases like for Mexico leasing and the first Lennox line of cases, Judge,
those talk about ghost tenancies where the tenant of record wasn't even there.
Right. They want them to be there. In other words, so what's happening here is if they're not there and they're upstate New York, the primary...
They're allowed to be upstate New York. They just have to have, under the code, they have to have a certain number of days that they spend in the apartment.
Yes, they have to be there over...
Okay, so you're saying that they don't have that number of days to be in the apartment?
Yes. In other words, if you read the affidavit of the tenant himself in the DHCR proceeding, he says, I occasionally come down to visit for work purposes.
But isn't that consistent, Counselor, with the Rent Stabilization Code, which says that the tenant, the succession applicant must reside with the tenant in the housing accommodation as a primary residence for a period of two, or no less than 2 years. So in other words, The succession tenant has to be residing there as his or her primary residence for 2 years and residing with the tenant. That's what the statute says, correct?
That's exactly what I'm saying.
But that's, isn't the record, doesn't the record support DHCR's position that in fact that's what occurred here?
No.
That they were residing with, not saying that it was that the tenant's primary residence, but residing with the daughter in the apartment. And the daughter had as her primary residence for 2 years.
No, Judge. First of all, they gloss over it. They say they've been signing leases and there's no evidence that they didn't live there, but they gloss over it. They don't analyze whether they lived together, whether the daughter lived there for the 2 years. And the 2 years is very important. It's 2 years when they vacate. So those 2 years, Judge, could go back from 2015, okay? Because that's when they claim they moved out of the premises and moved upstate New York. But the bottom line here is that what occurred here was summary judgment was granted in so many words, in an administrative fashion, without a hearing, with no discovery.
But wait a minute, let's just talk about that issue.
Okay.
So you assert that you filed a holdover proceeding.
Correct.
You do nothing else. You don't go into court. You don't seek discovery. You don't seek to stay the proceeding, to get discovery. You do nothing. You sit on your hands. And then so the record is the record at that point.
Well, we did seek discovery. We got a discovery order in the housing court case. Judge Sikowitz granted discovery in the case. But what happened was, by that time, the decision was already...
Well, then why didn't you move for a stay of the DHCR proceeding?
Your Honor, they were asserting a lack of personal jurisdiction, and we had to go through that whole dance. They claimed that they weren't served, so we had to go through this whole...
That has nothing to do with the DHCR proceeding. You could have, it seems to me that you could have put your assertions, your arguments that you're making now in the DHCR proceeding. You never did.
Your Honor, there is no motion practice in DHCR. You can't move to stay at DHCR proceeding.
So I'm going to humor me in this one. I'm going to agree with you. Let's just say the housing court proceeding goes forward, and you get a finding from housing court that the tenants of record were not, this was not their primary residency. Okay, let's just say that's what you want, right? You want the housing court judge to say, this is not your primary residency. How's that going to affect the succession rights?
Oh, because if it's not their primary residency and succession is denied, then the landlord gets possession of the...
No. Because the succession rights, if you look at it, as my colleague says, is looking back 2 years. You get a non-primary residency finding in housing court. That's prospective. That's going forward. You're out. You're out as a tenant. Your tenancy is over at that point when the court makes the finding that this is not your primary residency. It doesn't affect how 2 years prior, whether or not you're a primary resident.
Well, they still, if we win, if we win on the non-prime judge, then they can come in with their succession defense and litigate that within the confines of the housing court. Under NYU versus...
It's too late. It's too late because you did nothing in the administrative proceeding.
Judge, despite the sufficiency of the papers that were put in, just like Your Honors know in any summary judgment situation, despite the sufficiency, the moving party still has to show facts sufficient to warrant the relief granted. And here, if you read their papers, I came down occasionally. That is not enough to show that they resided together. The law is clear on that. They have to show that they lived together for those 2 years.
He said, and then we're going to end, he said, he came down occasionally, but all of these documents demonstrate that he resided in the place. I mean, it's not just he said, whatever he thought, everything suggests, all of the documents, that he resided there. You can respond to that on rebuttal.
Okay. I'll respond on rebuttal, Judge. Thank you.
Yes.
Your Honors, may it please the Court, Russell Cericione for Mark Palomino's Office of Legal Affairs, for respondent, New York State Division of Housing and Community Renewal, and Woody Pascal. And so the court below properly held that our DHR's decision...
So let me ask the question. We know what happened. We fully know what the record is. My question is, and you heard what I said, let's assume that the housing court finds that they're a non-primary resident. Okay, that's what he's arguing, non-primary resident. How does that affect the succession rights dispute that's before DHCR? Tell me.
Well, the courts and DHCR have concurrent jurisdiction, and there was nothing staying the DHCR proceeding. The tenant filed her proceeding
You're not answering my question. I said, how does a finding in a court that this is not their non-primary residence affect the succession rights? Does it terminate the proceeding that you guys are holding with respect to succession rights, or you can still go find that the daughter is entitled to succession rights?
Correct. You can still find that the daughter is entitled to succession rights because the non-primary residency would not give the current tenant a right to a renewal lease. Really, on these cases, the primary residence issue is focused on the successor tenant,
So
and
it doesn't matter. It doesn't matter whether or not the DHCR waits for the court or not. I mean, because what was happening in the court side is something that really doesn't affect the DHCR's, analysis and finding in terms of succession rights.
right. And I mean, the court could have stayed DHCR proceedings at that point, but they didn't.
I didn't understand what you just said, I'm sorry.
The court could have done something with the DHCR proceedings, and they chose not to because the tenant filed their DHCR proceedings first. And
Were the affidavit, or was the affidavit, I think it's of the father, sufficient to have the residing with requirement?
on its own, no. The affidavit on its own was not.
So then how, because the adversary argues that there was an insufficiency of proof. So how was it sufficient to meet the regulation?
Was it all of the documents that he had?
Yes, all the documents they submitted along with the affidavit. So there was the father's driver's license, the father's driver's license.
Voters, taxes?
Yeah. The taxes from 16, 17, 18 demonstrated their primary residence in New York City. The apartment, utility bills, mail, and I mean, even the affidavit itself says, of the father says, my wife and I spent many days and nights at the apartment. Both homes served as our family's residences. That points towards they're continuing to co-occupy with their daughter, who's the succeeding tenant, who's using their
And there's no
apartment.
question that she was there for 2 years, at least.
She submitted sufficient documentary
She was there for
evidence to
2 years at
demonstrate
least.
that she was using the apartment as her primary residence.
Okay.
I mean, really, I don't see any cases that discuss that the tenant has to demonstrate primary residence. All the cases actually do show that the actual tenant has to co-occupy with the succeeding tenant.
Well, what about your adversary relies on the was it Third Lennox line of cases?
So Third Lennox was distinguished in BPP Streets Owner versus Nichols. And really the emphasis in the Lennox case was the misrepresentation of the tenants to the landlord. The tenant moved out 8 years earlier, never returned, and they never told the landlord about the sister living there.
So in other words, they could not meet the residing with requirement for the 2 years prior.
Exactly. They never co-occupied together for the relevant time period, which is the 2 years before the tenant permanently vacates. So I believe the appellant's reliance on that case is misplaced. And I mean, in this case, the tenants told the landlord in 2016 that the daughter was a co-occupant in the lease riders. And they did attempt to get her added as a tenant on the lease.
Thank you.
You're welcome. Thank you.
May it please the court, Andrew Luskin for Respondent Taraja Morel. I'm not sure if the court...
I was reading your argument. The court was inclined to lean in favor of the appellate until you spoke up.
Yeah, I had some work to do there.
Yeah,
yes.
You had a lot of work to do.
Yeah, I had a lot of work to do there, but I think I did it, and Justice...
And my point is, again, because of what you said, and I thought about it some more and looked into the record, is that the holdover proceeding is really a red herring at the end of the day, because it really doesn't affect the DHCR's analysis with respect to succession rights.
That's the point, because the succession rights and non-primary residence are apples and oranges, and the appellant was conflating the two. The Supreme Court, Justice Rackauer, at first misapprehended that. I was able to, she almost didn't want to listen to me at first because I came in at the end. But I explained to her that succession rights don't, under the law, does not require the tenant of record.
Yeah, and my understanding is in the non-primary, the fact that if you found, let's just say the civil court, or the housing court found that this was not their primary residence, that only affects them prospectively. It doesn't do anything in the past whether or not they were primary or non-primary, right?
That's correct. And therefore, the housing court, the issue before the housing court was non-primary residence. The parents weren't fighting that. They weren't claiming that it was their primary residence. They were saying it was a residence of ours. And the DHCR has made it clear that they look first to the succeeding tenant. Was the succeeding tenant in primary residence at the subject rent stabilized unit? If yes,
That's the daughter, In this case, the daughter.
Yes, in this case, the daughter. And then, was there cohabitation? Not was there primary residence of the departed tenant in the previous 2 years. So my adversary has made a big deal of this third Lennox case, a 2012 decision of this court. As the DHCR pointed out, it's nothing to do with this case. The administrative record shows that the parents were there until the last day of their lease. And therefore, there's no issue raised by Third Lennox. Justice Renwick, you had mentioned something about in the succession or looking at the parents, certain number of days in the apartment. I would like to suggest that it's not a quantitative analysis.
Well, that goes to primary residence.
Yes,
Yeah, no,
that's right. It doesn't go to,
that's
right, it doesn't go to succession. Here, the administrative record was more than ample. It was overwhelming.
Yes, I noted that, I think, with
Yeah,
DHCR,
and the
the
real
different
point is,
documents.
and I don't mean to beat a dead horse, but, you know, the DHCR sends a copy of the complaint to the landlord, and the landlord says, hey, we got a holdover proceeding pending in the civil court. We'll talk to you later. They could have, because the rent stabilization code in 2529.7, that's 9 NYCRR 2529.7, gives certain procedures that the DHCR could follow. There could be informational requests. The DHCR could hold a hearing. The landlord could have availed itself of that and said, I don't think there's enough evidence here. We want you to ask for A, B, and C, or we want you to hold a hearing, or we want you to issue subpoenas. And I think it was Justice Singh who pointed out, the landlord didn't do any of that. The landlord did not invoke any process available to it under the administrative code. So when they talk about deprivation of due process, you can't forsake due process that's available to you and then complain that you didn't get due process.
Thank you.
Thank you.
Your Honors, just commenting on the documents that Your Honor asked about. In fact...
Which documents? That I asked about?
Yes, the documents that
that went to support where they lived?
Yes.
Okay.
In fact, the documents were in favor of the landlord. The tax returns were all coming back to the apartment, not to the apartment, to the house up in Millbrook, New York.
That was just one of the documents. There were other documents as well.
Yep.
There was electricity, this and that. But
Yes.
what about the argument that they lived there?
Well, they say...
Even if they weren't?
They say themselves that they didn't live there primarily. They say
Okay,
they
but
lived...
what about what's just been discussed for the last 10 minutes, that, you know, the fact that they weren't primary residents is something that will end with that not getting another lease, and it goes...
Well, Judge, first of all the cases...
In other words, what really is the focus here is the succession tenant, the daughter in this instance.
Right.
And that she was there's no question that the parents lived there, so...
But they have to live there with her together,
Yes,
Your Honor.
they lived there with her together.
They can't come
lived there with her together. You said yourself that the father said that. He said, what was the word you used?
No, what
He
I
lived
said...
there sometimes?
No, he came to New York occasionally for
Did he say
visits.
cohabitation?
He only came to New York for visits for work, Your Honor. They admitted...
No, but you said he says in his affidavit that he lived there some of the time.
No.
Well, what
He
was it that
stayed
you
overnight.
said?
He didn't
What
live there.
was it that you said before?
What I said was
You didn't
that-
say anything about overnight. You said something else.
Yes, that he came down to New York to the subject apartment every so often.
Every so often, you said.
Yes.
So, you know,
certainly-
every so often can be a number of days. That can be months if you add them up.
Exactly. It
So,
could-
and during that time, they lived with the daughter. They cohabitated with the daughter,
But
right?
Judge, if they came down for 2 weeks during the year, and we don't know that, we have no, they're very.
Well, then you should look at the documents other than the tax, other than the tax documents.
But no
You should
single
take a look
document.
at those documents.
But Judge, that's why summary judgment is hardly granted in these cases, because no single document is dispositive in a non-prime. There's a Snowbird case where people file tax returns in Florida, right?
The question is whether or not she made out
the documents
what
that
needed
she
to be I'm sorry, I can't even speak anymore, under succession rights, right?
The documents that the daughter submitted, Judge, were totally not sufficient to show that she was even there for the required 2-year period. She had very scant evidence, just some credit card statements. She had an affidavit that she filed with DHCR that was supposed to be filed years ago. They claim that they lived together. That's a form that you fill out. And she did it when the case started, not years ago when it was supposed to be filled out when you file it. And all her credit card bills are very scant, a few months that don't even.
But DHCR decided that already.
Well, all I'm saying is the underlying case, and I'll end with this, the underlying case that was brought before DHCR is called a failure to renew lease case. To my knowledge, there is no such thing as give me succession case in the DHCR. This is a proceeding that's filed when the landlord refuses to give a lease. We showed why we didn't give a lease because we had a Golub notice that was sent months before showing that we're not renewing the lease because of non-primary residents. So that
Thank you. That's the end of that sentence.
Thank
You
you, Judge.
started 3 others.
Thank
Thank
you,
you
Your
very
Honors.
much. Thank you all.
Have a good day.
You too. 300 Wadsworth versus.
As I have the additional citations form filled out.
Okay, you can hand it.
And a copy to my adversary. I gave it to him earlier.
Okay, you can hand it to the officer. We'll get it. Your time is running, so you should start.
Yes, Your Honor, I'll get right to it. If it please the court, Richard T. Walsh of Horing, Wellington, Rosen, and Grugier. I represent the appellant in this case. As a matter of housekeeping, case I cited at point 4, page 39 of my appellant's brief, matter of West 58th Street Coalition Inc. versus City of New York, 188 AD 3D1 was modified and affirmed as modified by the Court of Appeals, 37 NY 3D 949 of 2021. It didn't affect the purpose for the site, but I just wanted to clarify that for the court.
Okay, look, what about, I think we have a case here that this law is not retroactive, right? This law has not been found, okay, let me say that again. This law is not retroactive.
It's
so
not.
It doesn't apply your client's repairs that were done before the law was enacted do not apply here to your benefit, to inure to the landlord's benefit.
Well, I think, Your Honor, that's exactly what the issue is. And here we go back to, we look at Regina. Regina cites to the St. James, the James Square case. Basically, where a statute upsets a person's investment-backed or reasonable expectations, it's retroactive. That's the point. If it applies to something that was started or finished before the statute came into effect, that's what makes it retroactive. And that's what the situation here my client has. My client undertook individual apartment improvements, Your Honor, not repairs, to upgrade an apartment that had been vacant for a number of years. They entered into a contract on May 1st of 2019.
Yes, we have that part, 30 days or so before the statute was enacted.
Closer to 45, but yes,
Okay,
but as before,
but
by the time the statute was enacted, the apartment was no longer habitable because of the work had been undertaken. Therefore, the work had to be finished. That's $99,580 of an individual apartment improvements, which would have resulted in a rent increase of $16,559.67. The HSTPA, when it came into effect, limited the increase to $83.33 under the circumstances. But it did something else. It fundamentally changed the nature of what an individual apartment improvement was. Before that, it was a permanent rent increase. The HSTPA made it a temporary rent increase, and then imposed new duties, which Regina says is not proper. It's a retroactive application, shouldn't be permitted. The landlord had to reverse those increases after 30 years, including any rent guidelines board increases that would have been added to the rent, that the $83.33 a month. And that's really what it boils down to. That's what made it retroactive. With regard to fact sheet 26 and operational bulletin 2016-1, those documents aren't based on the HSTPA or on prior law. They can't provide no support for my client to be able to rely upon them with any certainty. Therefore, they can't be permitted to stand. What DHCR did was mix and match. It took some things from the old law, some things from the new law, and didn't give any justifications to why it did either one of those things. If I were relying upon those things now, or my client was to rely upon those things, we'd be back with another series of Roberts cases for people challenging the landlord's decision to apply the fact sheet when it didn't comply with the statute. So that is an additional reason. Those fact sheets have to be thrown out. My client should be entitled to the full amount of the rent increase based upon the contract that was entered into before the statute started, and it's up to the courts to protect those. That was an investment-backed decision.
Were the IAIs ever completed? I mean, we don't.
They were completed after just slightly after the lawsuit was commenced.
Okay, so what, was there an attempt to go to DHCR, to get DHCR's position with respect to the IAIs and what you'd be entitled to?
There's no mechanism for doing that with regard to individual apartment improvements, Your Honor. If this was an MCI increase, there would be a mechanism. You'd have to file with DHCR an application to get an MCI increase. There's no such thing with individual apartment improvements. You only have a problem if DHCR decides to challenge you, the TPU comes after you, or the tenant says there's something wrong. And my client shouldn't be put into that Hobson's choice. My client shouldn't have to choose between getting sued by the tenant or being sued by DHCR or losing $99,000 worth of work. Actually, it would have been $84,580 worth of work. That's the danger. That's the problem. That's the issue in a nutshell. I'll save the rest for rebuttal.
Good afternoon. Matthew Grieco for the respondent. This court should affirm Supreme Court's dismissal.
Can you answer counsel's question? Because my question to counsel is, with respect to the IAI, is why he didn't move before DHCR to get some sort of determination? And the answer is that there is no mechanism to do that. Is that correct?
That's correct. And the apartment issue here is vacant. And the question of what rent might be charged for the apartment and whether any IAI increase will occur in the future is subject to a lot of variables, most of which have nothing to do with Wadsworth's constitutional arguments here. So because the complaint explicitly seeks a ruling as applied to the plaintiff, as reflected on pages 23, 28, and 30 of the record, it is unripe. But even if the proceeding were ripe, Wadsworth's claims would be meritless.
But what more could they do? All they can do is make get the IAIs and then presumably charge the rent, and they don't want to be in a position where then they get sued by either you or a tenant that it's an illegal rent. So what are they supposed to do?
Well, the ordinary process in any IAI rent increase is that the owner self-calculates, and then if there's a dispute later, it can either be in front of DHCR or the court. But the court systems don't generally get involved before that point. But even if the proceeding were ripe, the claims here would be meritless because the application that Wadsworth is challenging is a prospective application. They are challenging the application of the statute to a future rent increase. This case is not comparable to Regina or Harris or the other cases upon which my counterpart relies. Those cases involved instances where the question was whether the statute could change a property interest that the owner already had in hand. For example, changing the owner's liability for past rent contracts that were already completed, where tenants were long gone even decades ago, or in Harris, a judgment of possession that the owner had in hand saying it could be used for personal use. Here, the only thing at issue is whether the amount of future rental income that Wadsworth can expect under the statute. And it's very well settled under the ILFY case, under this court's decision in the Schutt case, which is in our brief, that an owner does not have a right to any particular rent formula for future leases that do not exist as to hypothetical future tenants based on past iterations of the rent stabilization law.
So if the statute that we're talking about only affects the propriety of the prospective relief, the relief going forward, it's not retroactive.
That's correct. The application that they are challenging.
And even if you have to go back to the repairs or whatever else was done, and it still is only relevant to the extent it will affect the future.
That is exactly right. And there's case law in our brief that explains that just because it looks to some event that occurred in the past, that's not a retroactive application. If it's about a future benefit.
And the other thing about the rental income is my colleague, about the rental income going forward, how do we calculate that? I mean, there are parameters within the regs in terms of how to calculate future rent. And if there is an overcharge proceeding down the road, I mean, there's a lot of defenses in terms that the landlord can assert to say, look, first of all, it's not willful, there was no fraud, all that comes into play to determine whether or not there's going to be damages or whatever, right? I mean, so it's not like that the landlord's going to be in the corner without any remedy.
Correct, which brings me back to the ripeness point that I adverted to earlier, which is the basis on which the lower court had decided the case, that even if Wadsworth is not ultimately entitled to an IAI rent increase, there are many reasons unrelated to the constitutional arguments they seek to bring in this as-applied complaint why that could occur. Unless the court has further questions, we would rest on the submissions in our brief.
Thank you.
I would point out, Your Honor, that DHCR's arguments are really a matter of form over substance. It is not a limitation it's a limitation on money my client's already spent and what it can do with that money. It's an existing transaction that's being affected. That's what makes it retroactive. And I can cite the court to a case.
But it's past conduct, either way. It's past conduct. It's money that was spent. It's past conduct that bears on a decision you want for the future, how this apartment will be changed.
But my client is being punished by losing a benefit for past conduct. And that's exactly what Regina and James Square, which Regina cites,
in other
holds.
ways. Okay.
Retroactively concerned, this is cited 35 New York 3rd at 382, cited at page 31 of my brief. Moreover, retroactivity concerns are further highlighted, whereas here the new statutory provisions affect contractual or property right matters in which predictability and stability of prime importance, impairs real property rights by diminishing or possibly eliminating the constitutionally protected return on investment owners realized in the past related to the use of their properties. That's exactly what my client was doing, relying upon an existing statute that gave them certain rights and remedies before the rug was pulled out from under them. The James Square case says that you can't do that. That's unconstitutional. And that's it. That's really what it boils down to. We did something, we started something, and now they want to say you can't do it. You have to do it this way, you can't do it that way. That's the problem, and that's what makes it retroactive. Thank you.
Thank you. Thank you both.
Well, that's 7 minutes. Bathroom is still open. Yeah, they still open? Yes. Okay. This way?